Maybe, I beg to mention item number 27. You can give me the posted after vacation. I need some instructions.
Anyone for the respondent?
The government,
Fixed matter.
government, my lord.
Any objection from the government?
PNR.
Have you informed them?
I think they don't.
Go and inform them. It's a fixed matter. It is a fixed matter.
My lord,
To inform the other side, why are you making a mention without informing?
I searched for them, but I did not get them.
So you wait until the matter is called.
Please, Lordship. Lordship, I beg to mention item number 14, my lord. I beg to withdraw it, Lordship.
14,
14, Lordship. Actually, I mentioned it for withdrawal, but it has been listed for others.
item 14 on the submission made by the council. Stands dismissed on the roll. Interim order, any stands vacated, pending either which dismissed. Liberty granted. Yes, sir.
May it please, my prayer for listing of a fresh motion.
It will come automatically. Why not?
My lord, it was filed 2 weeks back. It has not
2
come.
weeks.
Yes.
There must be defects.
My lord, I have cleared the defects also. Then also it has not come.
Tomorrow.
I am deeply obliged.
Wait, please, Lordship. That's why I'm doing for listing for withdrawal.
Withdrawal tomorrow.
On
Tomorrow.
Tomorrow. Published.
Made resolution. I beg to mention item number 3 of today's list, Lordship. I want to withdraw this matter, Lordship.
The submissions made by council for petition and petition stands dismissed on withdrawal. Interim orders, if any, stands vacated. Liberty granted. Pending ayes are also dismissed.
Obliged.
My lord, item 16, 17 and 37. Mostly
16, 17.
and 37, my lord. After vacation, mostly fix a date, my lord.
Huh?
After vacation, mostly fix a date. my lord.
Anyone for the respondents?
I am for the petition, my lord. I am for the petition. This is for correspondence.
Item 16, 17 and 37. On
Mine.
the request made by council for the petitioner stands referred to be listed out in the month of November on a date to be fixed by the registry. MSMD Bora, council representing the transport department does not object to it.
Your Lordship, I beg to mention for listing of a writ petition, Your Lordship. It was last mentioned the month of May and notices were waived off, Your Lordship. We want it to be listed because the DPC promotions are scheduled to be held very soon.
It's for admission.
Yes, Your Lordship, for admission. Can it be listed on this Wednesday, Your Lordship, 24th?
Thursday.
Much of this, Lordship.
May I please, your lordship? Lordship, I beg to mention item number 32, your lordship.
Item
Number 32, lordship.
32.
It's kindly grant us some time, lordship. We want to file out affidavit in opposition, lordship.
You are for respondent.
Yes,
Have
lordship.
you informed petitioner?
Yes, with the consent of the petition.
Item 32 stands referred to be listed after 4 weeks. On a mention made by the, on a prayer made by the council to the respondent. You submitted that consent of the council to the petitioner has been obtained.
Yes, your lordship.
Notice.
My lord, at this notice only, my lord.
Only one thing, Lordship, respondent number 3 signed the contract agreement. Perhaps he has not been served, their name has also not been served. State of Mizoram, Lordship.
But I think ZA Mizoram, we had served, my lord. If not, I will, my lord, immediately.
Respondent 3.
He signed the contract agreement.
But you serve copies on the.
My lord, my lord.
Third council for parties issued notice which are for 4 weeks. Mr. B. Chakraborty represents, CGC represents respondent number 1 and 2. MSP Bhattacharya, government advocate. I think she is the government advocate.
My lord, my lord.
Government advocate represents respondent number 3. The notices, the respondents are represented, notices waived, extra copies will furnished within a period of 1 week from today. Extra copies, please start. Respondents may file their objections.
And name of GA Mizoram may be reflected.
My lord. I'll serve today. only.
Registry will reflect the name of G. Government Advocate Mizoram. The cause list on the next day.
Deeply.
In fact, there were 4 cases, today only 1 had come. And these are peculiar because of the court judgment, the arbitration clause itself, my lord, cannot be functional. So we have to come under the 11-6 directly.
Curated panel.
My lord, curated panel. Okay.
Please, Lordship, my lord, this case relates to the
Some
non-payment.
instructions were,
Yes, my lord, we have forwarded it, the pension papers to the Office of Accountant General, man.
yes, accountant general.
My lord, so far, my lord, I have not received instruction, my lord, so I need three days time, my lord. And my lord, this so far provisional pension is, my lord, this, department is dealing with the provisional pension, my lord. Yet, even then I will take instruction, madam, fix on 25th of this month.
Have you decided, Mr. Bothakur, have you decided on the provisional pension?
Yes, my lord, provisional pension papers have been forwarded, not the final one.
Provisional pension.
My lord, that letter will be, my lord.
You hand him over a
Yes,
copy of the
I'll,
letter.
My
today
lord,
itself.
they are, what they are doing, my lord, they are sending one after another document, my lord, and this lordship kindly have a look what they are doing, my lord.
So let the matter be listed on Thursday. 25th, Mr. A. Bothakur and Mr. S.K. Medi. A. Bothakur.
I Bothakur,
standing
ma'am.
counsel- I. Bothakur, standing counsel forest. Mr. S.K. Medi, that of CGC appearing for the.
My lord, standing counsel, my lord.
Standing counsel, accountant general. Accountant general.
Yes.
My lord, the department is excise, my lord.
Sorry. I. Bothakur for excise. Standing counsel, accountant general, will complete their instructions and apprise the court as to the steps taken for release of provisional pension. So it was made clear that the department will ensure release of provisional pension. Commissioner, in terms of the without any further delay. This from Friday, Thursday.
Copy, my lord, he will.
You serve a copy?
Yes.
Immediately.
No paper, so my lord.
May it please your lordship. Well, on the moot issue, my lord, I'm a retired person and page 52, my leave rules, there is no objection to that. I mean, leave encashment, what is to my credit. However, authorities are not releasing that.
Yes,
To my credit, there are
instructions.
it's only quantifying and paying,
Huh? As per the last
300.
order, you were supposed to get instructions.
Correct.
Our instructions are awaited, my lord. But otherwise, by operation of Rule 20(1) of pension rules, my lord, if there is a pending case going on, my lord, usually gratuity and leave encashment is not.
It's not usually, either there is a bar or there is no bar. May I invite my lord's attention to page 53 for a moment? It's a notification of the government of Assam. Page 53, my lord. May I, prior to that, page 53 for a moment,
Yes.
May I read that?
Regulation,
May I read?
Yes, yes.
In pursuance to the approval of the cabinet held on 7/6/12, the governor of Assam is pleased to order that henceforth all administrative departments, heads of department and heads of offices of the district shall issue provisional pension, provisional family pension and DCRG to all retired government employees of the state of Assam as admissible soon after their retirement till the final PPO is issued by the Accountant General, A&E Assam and Director of Pension Assam as the case may be under the provision of Rule 22(1) of the Assam Service Pension Rule 69. It is clarified that the retired government employees against whom any departmental or judicial proceeding is continued, no DCRG shall be paid to him until the conclusion of such proceeding and the issue of final orders thereon. Leave encashment does not fall under that head,
Has it been modified, this particular?
Yes, my lord, let me place it on record, my lord, our instruction. I'm seeking some time, my lord.
What instructions?
Why it has not been released, my lord.
We are asking you this page 53, has it been modified, withdrawn, recalled?
Yes, ma'am. This is there, my lord. This is in pursuance to that rule 22.
No,
Rule 22(1) is almost same for, not parameteria though, but it borrows from there. Lordship would have it, Rule 22(1) of the Assam Pension Rules 1969.
yes. Rule 22 mandates
Mandate.
payment of provisional pension.
Provisional
That
pension
we are getting.
has been paid.
That we are getting.
That
That
you are
is,
getting.
That we are getting. Gratuity we got. The only thing is that leave encashment, that's computed but not released. And the stand they are taking is not substantiated by law.
The Rule 22 does not prohibit
Does not.
release of earned leave or leave encashment.
Does not.
It is only with the CRG.
In fact, the Joint Secretary Government of Assam Environment Forest Clearance Department, whom he represents, my lord, by page 51 communication, had a
Notice has not been issued here.
notice not been issued, my lord.
Then
What I
notice
pray,
is
my lord, once things set in motion, it could go in motion, admission orders and affidavits. They can have the instruction, my lord. Page 51 for a moment, my lord, what their officer has done, supported rather. Page 51, my lord. That's what the Joint Secretary Government of Assam Environment, Forest and Climate Change reads. So with further reference to the subject cited above, I'm directed to request you to kindly furnish leave admissibility report in respect of Shri Vinod Kumar Pine, retired DCF, concerning the proposal for sanction of leave encashment benefit in lieu of unutilized earned leave to the department at an early date. There's no whisper as to any prohibition or embargo in law.
Wednesday.
Wednesday, my lord. Motion.
Wednesday, my lord, get in.
Yet all your instructions or we are issuing a direction.
I'm grateful, my lord. Obliged.
To be listed on Wednesday.
The motion, where is the?
Mr. Rai Kotak. Standing Council Forest.
My lord, may I pray that I may be given time till Friday, my lord. If
And they're pushing it to the edge.
Thursday, then my lord.
Thursday.
Motion. Obliged, Lordship.
Thursday. We complete his instructions. Please be got. So. Leave encashment.
Leave encashment.
Let matter be listed for Thursday.
Obliged. I will.
Mr. C. Borwa.
For 10 and 11 million, 10 and 11. Right, on it.
Item 5, Lordship, I need some more time, Lordships. That Lordship kindly see the last order. Their authority is going, well, some process is going on, Lordships. So,
Sometime means it goes after vacation.
Lordships.
Yeah.
Only because of my lord that the persons, the selection for the so my lord, taken by the deputy commissioner.
Oh.
Now he is holding the post of director of land
Alright.
records. So he could not be taken that.
On the request of the learned standing council. Then given disaster management matters stand referred to be listed on 17th October.
Lordship.
Mr. A. Alim appears for the petition. List accordingly. Mr. Bora, you are appearing.
3 and 4. 3 and 4.
Mr. B. Bora, appeal for 3 and 4.
Obliged.
Lord, I have filed the affidavit in this one.
Made please, your lordship.
Yes, affidavit has been filed. Have you
Yeah.
received a copy?
I have received a copy, your lordship. I'd like to file a reply also if.
You file your reply? Then let us issue a notice here then.
Lordship.
Third council for party and issue notice. 3 weeks. Mr. Ganguly, standing council, Grameen Vikas, Assam Grameen Vikas Bank has already filed an affidavit. In terms of the earlier order dated 15/9/2025. The petitioner seeks liberty to file his rejoinder. List again on 27th
20.
October.
Interim order.
No,
There is a stay on his transfer. Can it be a little earlier?
so 17th,
7th. Deep report.
interim order passed earlier, may continue.
Obliged.
That was.
Not matter pertains to my lord compassionate appointment. In fact, it is a third round of litigation. Lordship may kindly peruse my lord page 27. If Lordship in the first round of litigation, direction was given to place my matter before the DLC. But at no point of time they have placed my matter before the DLC. Thereafter, my lord, I have
Which
page 27, Lordship.
27.
Last paragraph. In view of the submissions made by the counsels for the parties, the respondent number 4 is directed to send the application of the petitioner 1 made on behalf of the petitioner number 2 for compassionate appointment to the respondent number 3 to place the same before the concerned DLC for consideration of compassionate appointment in its next meeting.
But who is for the respondent? Will issue notice here. Third counsel for party. Public health engineering. You are
Yes,
appearing,
Lord.
Mr. Lord.
My lord.
You are appearing for public health.
No, my lord, for PHE. PHE you have been?
Mr. High Court who appears for respondent 1, 2, and 4. Mr. R4 for respondent number 3.
Respondent number 3, my lord.
The respondent are represented the notices a way picture of publicly furnished with the period of one fiction. Placed after returnable.
Might be the lordship. What should APSC matter, your lordship? Lordship has issued notice. (2016) batch.
You are already terminated.
Lordship.
Huh? Why do you want to stay?
Because the order has been passed in violation of the court's order, your lordship.
But you're already terminated.
Terminated, your lordship. The similar stay has been granted in similar matters, your lordship.
Maybe. Heard counsel for parties, if you notice, returnable. After 4 weeks. Returnable on 3rd of November.
Similar matters, which one I think, your lordship?
Mr. CKS Barua, the governor, appears for
All respondents.
all the respondents.
All respondents.
Therefore, notices the way, our extra copy to furnish within a period of 1 week. Issue notice on the interim prayer. Prayer to be considered on the next returnable date.
Similar matters, lordship has passed.
You asked, you have not argued. You argue the matter.
Lordship. Your lordship.
You argue the matter.
Yes,
You're
lordship.
not arguing the matter, you're asking for a stay.
No, lordship. Then in this case, what happened, your lordship? This is
We'll hear you on the returnable date. You're issuing notice on the stay, letting complete. You're not affected otherwise.
even otherwise not affected, but
Then-
since stay has been granted to similarly situated.
Maybe.
persons, that is why.
Maybe on whatever grounds, I don't know what grounds we had issued an interim order, but we have issued some interim order.
Yes. Place that mainly on the ground that, your lordship, that since the court's order was that they should be reinstated because they have completed the period of probation. This is a case where the parties have, petitioner has completed
We'll
his.
examine it. on the
Lordship.
returnable date.
Oblige, lordship.
Fair, your lord.
Lordship, this matter relates to compensation department. Lordship, I am challenging the OM Lordship, dated 18/9/2024 Lordship. What happened in Lordship? Petitioner's case was
All right, we'll issue notice. Issue notice, right, counsel for partner reviews. It has been 4 weeks, Mr. CPL, the representatives. All the respondents?
Yeah.
Hmm?
Yes, Lordship.
All the respondents. The way the extra copy.
Except 4 and 5. 4 and 5, I don't appear.
Said all.
I'm sorry.
Appears for respondents 1, 2, and 3. And Mr. Who appears for excise?
Excess or finance, Lordship?
Huh?
I think finance, excess or kind of finance, right? Excess or kind of.
Who appears for excise?
PN was submitted.
Mr. PN for excise department.
And GAD that, A for control.
GAD. Council represents responsible notices of the technical policy furnished for
Not
the
always.
period of 1 week.
Well,
I can tell.
Let me tell Lordship. Lordship, considering the fact that if a person who is a caregiver to a person with a benchmark disability will cause difficulty in the family, Lordship, the government of India issued a OM that your Lordship will find at page 32, that is Annexure 1. Lordship, this came subsequent to the Persons with Disabilities Act 2016, where under Section 2R, the benchmark disability is given as 40%. Now, Lordship will see, considering that the transfer of a government employee who serves as a main caregiver of a person with disability would have a bearing on the systematic rehabilitation of persons with disabilities, the government issued OM on so and so to exempt such employees from routine exercise of rotational transfer subjected to administrative constraint. The scope of disability initially had covered. Lordship, the relevant here would be the locomotor disability, which is at number 3. The government employee, the down below, Lordship, the government employee who is a caregiver of a dependent daughter, son, parents. Here the issue is the father. With specified disability as certified by the certifying authority as a person with benchmark disability as defined under Section 2R of the Right of Persons with Disabilities Act 2016 may be exempted from routine exercise of rotational transfer subjected to administrative constraints. And the next page, your Lordship will find at page serial number 3, the term specified disability as defined herein is applicable as a ground only for the purpose of seeking exemption from routine rotational transfer by a government employee who is a caregiver of a dependent daughter, son, parent, spouse, brother, sister, as stated in para 3.1 above. Pursuant thereto, Lordship, the State Bank of India issued a circular that is at page 33. This is specifically relating to transfer and posting of employees who are caregiver of the disabled dependent. This is parameteria, same language as was used in the OM. Only Lordship will turn to page 35. There are some additions. Rotational transfer of such employee may be done, that is, they may be transferred within the center, keeping in view of the CVC guideline. In case no vacancy exists at present place of posting on promotion, these employees may be transferred at other centers based on their choice of place where required medical facilities are available. In 2025, Lordship, the SBI brings in the policy for transfer of officers. Now, your Lordship will turn to page 39.
Yes.
Page 39, serial number 2, your Lordship will see in the table given, region or center state. The petitioner here is posted in the center. So, Lordship, the maximum term is 5 years. But Lordship will again come to page 44, 4.5.2. This gives an exemption to this kind of government employees or employees of the state bank who are caregivers of their dependents. Now, Lordship, the petitioner's father is a person with a benchmark disability of 40%. Lordship will find the certificate at page 63. He suffers from locomotor disability.
Petitioner's father.
Father. Lordship will find it at page 63. Their ABCD is given, Lordship. The petitioner's father, here, he is a case of locomotor disability. Name of the affected body part, both lower limbs. Diagnosis in his case, weakness of both lower limbs due to diabetic neuropathy. he has 40% disability. Lordship, on receiving the certificate, the petitioner made the application. He had updated the instructions on 29th of May 2025. Lordship will find that at page 73. It is a portal of the State Bank where he has informed that his father is suffering from disability.
$70.
73, Lordship, Annexure 8. Lordship, Kiranmoy Debroy, the father of the petitioner. On the right side down below, Lordship. Lordship will see the differently able date, 29 May 2025.
Now, where is the impugned order?
Lordship, the impugned order, Lordship will find at page 75.
Fine.
Lordship, as serial number 2 is the petitioner. He has been transferred from SMECC Guwahati to Borpeta region. In violation of their own guideline, in violation of the OM issued by the Government of India.
Where is their guideline again?
Lordship, the guideline your Lordship will find, the uniform policy your Lordship will find at page 44. 44, Lordship, 4.5.2, transfer posting of officers who are caregiver or disabled dependents. If I may read, Lordship.
Yes.
Transfer posting of officer who is a caregiver to a disabled dependent shall be governed by the instructions issued by the bank in this regard from time to time. In terms of the instructions issued by the bank in compliance of the DFS guideline issued by letter so an employee who is a caregiver of a dependent daughter, son, parents, spouse, brother, sister with specified disability as certified by the certifying authority as a person with benchmark disability as defined under section 2R of the Right of Persons with Disabilities Act 2016 may be exempted from routine exercise of transfer/rotational transfer subjected to administrative constraint. The term special disability as defined in the schedule to the Rights of Persons with Disabilities Act 2016 covers as serial number 1 locomotor disability. Lordship, I can leave the rest. If your Lordship turns to the next page at page 45, the term special disability as defined herein is applicable as grounds only for the purpose of seeking exemption from routine transfer, rotational transfer by an employee who is a caregiver of a dependent daughter, son, parent, spouse, brother, sister as stated above. The employee have to submit a copy of the disability certificate issued by the designated authority in respect of their disabled dependent. Now, Lordship, I have shown your Lordship that he has already informed the bank on 29/5/2025. And the last point, Lordship, the rotational transfer of such employees may be done. That is, they may be transferred within the center, keeping in view the CBC guideline. In case of promotion, there is an option given that you can choose a place of posting where health services are available. Proper adequate health services are available.
No, this is not promotion per se.
No, Lordship, this is a transfer. So, Lordship, I will be covered by the first part.
Vacancy arises.
Lordship, I will be covered by the first part. Rotational transfer of such employees may be done. That is, they may be
What is the
transferred.
CVC guideline?
CBC guideline, Lordship, we don't have, Lordship.
Huh?
This is a bank's own guideline, Lordship, some CBC
It
guideline.
says CVC guideline.
It says, Lordship. So, Lordship, my issue is that
Where is your transfer order?
Lordship, my transfer order is at page 75.
Fine. Did you represent before?
Yes, Lordship, we represent, Lordship. Representations, your Lordship will find at Annexure 12, which starts at page 77. And these were rejected by order, not an order, an email. That is a view of the authorities at page 84. Lordship will look into it, Lordship, first. At page 84, the rejection. There is a view of the HR department. During his probation period, he was posted in and around Guwahati Center within 30-kilometer distance. Upon confirmation, he was posted at branches within Guwahati Center since February 2020. As per circular on uniform transfer of policy for officers up to MMGS 3, that is the grade, Lordship, dated 5/5/25, the maximum tenure of stay in a region/center is 5 years. Sri Dev has completed 5 years in the center as on 31/3/25. Even this is wrong, Lordship, because in the policy of uniform transfer, it says that the date to be reckoned is 30th day of June of that month, of that year.
Yes.
Then Lordship, as per records available in HRMS, Sri Dev has not marked his father as a disabled dependent in HRMS as on 31/3/25. Now Lordship, where this 31/3/25 comes into play is a debatable issue. Because there is nowhere mentioned anywhere that 31/3/25 he has to inform. And he will inform only after he has received the certificate from the competent authorities. In this case, Lordship, he has received the certificate in respect of his father only in the month of May 25. So there can be no question, Lordship, how can he give a certificate prior to the date of issuance of the certificate?
No. This reflection of the particulars in the web portal,
Yes.
is it mandatory for all employees?
No, only for the person, yeah, Lordship. We have to inform about all the dependents. So among the dependents, I had marked my father as a as a person with disability.
When did you do that?
Lordship, on 29 May, on the day I have received the certificate.
Who's for SBI?
SBI, Lordship, they have their councils, but Lordship notices to go to them. So Lordship, what I'm praying for at this stage is Lordship will stay this order of transfer.
Where is your statement that you have not handed over the charge?
Lordship. Para 25, Lordship. I'm sorry, Lordship. That is para 27, Lordship. If I may read para 27. The petitioner humbly begs to state and submit that he has a strong prima facie case in his favor, as has been conclusively demonstrated herein above. The impugned order of respondent is expressly illegal. That though the transfer order has been issued on 29/7/25, but the petitioner has been granted sick leave with effect from 1/8/25 to 31/8/25. Thereafter, the petitioner had applied for further extension of his sick leave, but on account of the fact that the approver is not available in the case of the petitioner is unable to ascertain the current status of his application for
Who is the
extension.
approver?
Approver is the authority, Lordship, to whom I am going to report. Once I'm transferred, I have to report. Once I report to an authority, he becomes my approver. So as on date, my applications for leave are also pending.
You go and join.
Lordship.
Who else is there in your family?
Lordship, his wife and a minor child of 4 years. A daughter of 4 years, Lordship. That is his difficulty, Lordship.
Where are you transferred?
To Borpeta, Lordship.
Borpeta. Borpeta is nearby.
Lordship, but the petitioner's father is in a very bad position, Lordship. He may have to be transferred to the hospital at any point of time. He is unable to stand up. He falls down if he stands up. That is the difficulty. Because Lordship, here the violation, the guideline of the SBI, they have themselves violated. And this 31 March, Lordship, from where they have got, Lordship, that is a question. Because the transfer policy, if your Lordship sees.
This issue notice returnable for which petitioner is an employee of the SBI posted in Guwahati. Is agreed by the transfer order dated
29/7.
29/7. Why have you come so late?
Lordship, we had made these representations, they were rejected from time to time. We have informed them that there are guidelines. You are not following the guidelines.
29/7. Which page number?
Page number 75, Annexure 10.
29/7. Whereby the petitioner, whereby this common order petitioner was transferred from Guwahati to Borpeta region. His name appears at serial number 2. Say go ahead. So the petitioner submits that he is the caregiver to his
Father.
father, to the person with disability, benchmark disability of locomotor disability. He is unable to move as because of the ailment suffered by his father. And he claims to be the only caregiver in the family. Therefore, as his father requires constant medical attention, he is transferred to Borpeta. We put him in a position where he will not be able to give the necessary care to his father, which is required. So, counsel of the petitioner has referred to the office memorandum dated 7 February 2019, issued by the SBI regarding the transfer and posting of employees who are caregivers of disabled dependents. Stop. And in terms of the same circular, employees have to submit a copy of the disability certificate, and they may be exempted from the rotational transfers. He has also referred to the uniform transfer policy of the bank, where at clause 4.5.2, caregivers of disabled dependents are exempted from rotational transfers. So he submits that he had the petitioner represented before the authorities, highlighting his condition that he's the caregiver of his dependent father, who's suffering from locomotor disability. However, the same is rejected on the ground that no certificate was uploaded in the web portal. It is submitted that the certificate, which have been this medical certificate received by the petition, was uploaded in the web portal on
29/5/2025.
29/5/2025. So under such circumstances, the counsel for the petitioner submits that this transfer order, interim transfer order, is contrary to the transfer policy itself. Therefore, praise for appropriate orders and during dependency, praise for suspension of the operation, praise for a stay. Having heard counsel for parties and counsel for the petition and upon perusal readings, perusal of the petition and the enclosures, you see that the SBI has a policy of exempting caregivers of disabled dependents from rotational transfers. So from the documents, it is seen that the petitioner has a dependent father who's suffering from locomotor disability. So prima facie, it appears that the fact that the petitioner is the caregiver of a disabled dependent, namely his father, has not been taken into consideration by the bank authorities. Accordingly, till the next returnable date, the impugned order dated so and so, so far as the petitioner is concerned, shall not be given effect. The SBI is not represented by any counsel. Therefore, notice issued. Steps on the respondents by registered post as well as usual post within 1 week from today. Petitioner will also take steps by Dusty and file necessary affidavit for this court.
Lordship, Dusty, we can take from 2 to 6, Lordship.
Dusty in the local, Dusty on respondents 2 to 6. Who has issued the transfer order?
Lordship, the Chief Manager HR, it is the respondent number 2.
We'll take Dusty on respondent 2. Respondent 2. Matter be listed on.
Lordship, respondent number 6, I'm sorry, Lordship.
Respondent
6.
Matter be listed on 3rd November.
Deeply obliged, Lordship.
May it please your lordship, matter relates to compassionate appointment lordship. DLC recommended lordship, SLC rejected due to balance 3-year service. Thereafter, petitioner approached before this honorable court lordship. The honorable court remanded back the matter to
Why
the
have you not
SLC.
applied for the, in terms of the executive order? Did you
Lordship-
apply?
Lordship, as per notice dated 38/2025, Lordship,
Ah,
petitioner applied,
Submitted.
submitted required particulars.
So it will be taken care of. Why have you filed it now?
There is nothing left, my lord.
Why have you filed the writ petition now? Your case will be considered in terms of the uh, materials you have submitted on 38.
Lordship, in the meantime, OM has come 18/9/2025.
89 is prior to
There is a
that.
bar, Lordship.
89 is prior to that.
Case 33, SLC rejection.
You come back after the, any orders are passed, not now. 38 you have already submitted.
Yes,
Let some order be passed.
My lord, if any orders even will be passed also, my lord, that will give a fresh, rise to a fresh cause of action, my lord.
That is what we are saying. What is your prayer here? You are challenging the notification.
yes.
But you
OM
have
dated
already-
18/9.
You have already submitted before the authorities.
Yes,
Why have you challenged it now? It will be listed after 3 years. And permitting the petitioner to complete his instructions. Mr. Raghov, if you have to respond. You first understand why you are filing the writ petition.
yes.
Wait, please, Your Lordship. Lordship, in this case, the petitioner is aggrieved by the fact that he has not been paid salary for last 16 months, Lordship. He's a grade 4 employee and till date, no salary has
Who is
been
for the respondent?
responded, Lordship.
Fishery.
Fishery Department,
You have
Lordship.
submitted copies.
Yes, Lordship, we have submitted copies.
Now petitioner is aggrieved by non-release of his salary. For which period?
For, from April 2024 till date, Lordship.
April 2024. Till date. Stop petitioner claims that was appointed as grade 4 fisherman under the Fish Farmers Development Agency, Lakhimpur, on 2005/1997 in the regular scale of pay, and he has been continuously discharging his duties till date. However, the salary with effect from April 24 has not been released without the reason. Since none represents the fishery department, we request the MS M. Bhattacharya, additional senior government advocate, to obtain required instructions in the matter. We are permitting you to obtain instructions here because fishery council is not here. You serve extra copies to her during the course of the day.
Lordship.
Matter be listed immediately after the oath.
Once of it.
May I please, Your Lordship. Matter relating to dismissal from service under first Assam Police Battalion, Lordship. Nazir, Lordship.
You have filed appeal also dismissed.
Yes, Lordship.
Heard counsel for parties. Issue notice written about 4 weeks, MSU Sharma.
For all respondents, sir.
Represents all the respondents, therefore notices are waived, extra copies we furnish within a period of 1 week from today. Let the records pertaining to the departmental proceedings be also called for. for perusal of the court, if the need so arises, by the next returnable date, is on 11 November.
I'll have like
And it is the commissioner for MSN Pasachani, additional senior government advocate appears for the response. This again. Thursday.
Deeply obliged.
My lord, in this case, I have sent email on 17, my lord, I have not received instruction till date, my lord. So, my lord, the time on 26th, my lord, again, I'll try, my lord. 26. 25th.
on 25th, my lord, only date of birth issue is there, my lord. They have recorded.
Property for the children, Mr. S.K. Mehdi, London CPC. The respondent, Mr. Mehdi submits that instruction sought for has not been received. The praise submits of the matter be listed again on 25th. Permitting him to complete the instructions. As agreed, list on 25th. of the-
If your lordship kindly peruses the last order, my lord. The last order dated 17/9/2025. Paragraph 8, my lord.
September, day after. Yes,
Paragraph 8, my lord. Last order dated 17/9/2025.
what are you referring?
My lord, the last order passed by your lordship, my lord. Order dated 17/9/2025. Paragraph 8, my lord. Let notice be issued returnable by 4 weeks. Sri so and so, my lord, appears an accept notice. Also heard on interim prayer, and your lordship had granted status quo. And matter was fixed after 4 weeks. So this should have been come on admission, my lord.
No, it has been fixed.
Wrongly listed for
We
motion.
have written here that it is listed on the request made by the.
At the request. But once notice issued, normally it comes for admission.
Normally it does, but he has requested. So. Yes.
Well, may I, for a moment, lordship, may I have a look at this particular Assam Services Disciplinary and Appeal Rules. Rule 23.
Assam.
Assam Services
Disciplinary and
Disciplinary, yes, sir.
Yes.
23, my lord. One says in case of any appeal against an order of
That we
suspension.
have already seen.
No, my lord, it's necessary, my lord. I will point out some documents in the writ petition to today. So lordship will see, my lord, here, my lord, provided. This is the main, my lord.
We had granted status quo order, Mr. Gogoi. I thought you will, as far as I recollect, you said you were presenting some judgments or something like that.
Oh, lordship will see, my lord. Then in that case, the manual part, my lord, the whether that hearing is required or not.
That we'll examine it.
8.6.9.
That will
It's
examine.
very clear from here, my lord.
We'll examine that. Let it come after.
No, 8.6.10 says, my lord, thus I am reading, it is not necessary for the appellant
No,
authority
Mr.
to hear the
Gogoi,
appellant.
I had heard you on this.
No, then, my lord, lordship may see the so cause for a moment in the writ petition, not the rules, my lord. Page 47.
Yes.
You are hereby required to so cause under Rule 9. It was followed, my lord, under so and so, and Rule 7, my lord, lordship will see. Both 9 and 7 has been followed. That's why the proviso number 3 of Rule 23, it applies, my lord.
You where this 9 and 7 is followed, no further notice is required.
Yes,
your
that's what,
case.
that's the main issue. That's why I'm saying it's there in the rules. And my lord,
Really.
8.6.10 is very clear. It says no hearing is required.
We'll have it immediately after reopening.
Then lordship will give a date on the reopening.
15th, my lord.
16.
16, my lord.
The other matter is on 15, my lord.
Let it be on 16.
Both.
15th. What is the other matter?
I have challenged the penalty order.
Penalty part.
That
Because-
has become infructuous.
No, my
now.
lord, both can come together because my grounds to the challenge to penalty order is in that writ petition, my lord, on 15th. The lordship will fix up 15 and the lordship will examine both on 15.
15, all right, 15.
Fifteen.
It's not 15.
Interim protection may continue.
Status quo order granted will continue
Obliged, deeply
till
obliged.
15th October.
Not saying in this case, Your Lordship, we have to change the CC, Your Lordship, selection, Your Lordship, in 2013, Your Lordship. In
Yes,
respect, of-
challenged or you want the direction to implement the recommendations.
that is Your Lordship, and Your Lordship, in view of that, Your Lordship, we have filed this, Your Lordship.
Notice student,
Lordship.
right? Mr. Reyes, what have the council for the petition, we issue notice. Or Mr.
1 to 4.
You want to obtain instructions or?
Yes, Lord, definitely.
Huh?
Respondent number 1 to 4.
No, first you obtain instructions here. What is the status? Essentially, it is adopted by the cabinet.
Lordship, but Your Lordship, action taken report has not been.
That information you give us on the next day. If after that, if it is required, we'll issue. notice.
Lost.
Mr. Reyes, what happened? For the petition. And Mr. C.K.S. Burwa, learned government advocate appearing for respondents number
1 to 4.
3, 4. MS,
PP does Lordship for respondent number 5.
he does for respondent number 5. You are appearing for personnel also, 1,
Yes, sir.
3, 4.
Yes.
PP does for 5. Petitioner before this court essentially has moved to challenge has sought for a direction from the court to implement the recommendation made by the one-man inquiry commission headed by Justice P.K. Sharma within bracket retired. And the action taken report. The same recommendations, some which has been placed before the government. Further prayer is to set aside and quash the entire selection and appointment of all candidates belonging to the Common Competitive Examination - 2013 and other consequential actions. So, at this stage, the court permits the government advocate to complete his instructions as to the status of as to the implementation of the recommendation of the one-man commission one-man inquiry commission. Let these instructions be placed by the government advocate on 17th October.
Lordship, deeply obliged.
I think Make previous, my lord. There are 2 writ petitions, my lord. My lord, may kindly take up WPC 5555, my lord.
Yes.
When the petitioners in both the writ petitioner have challenged the order of suspension, amongst other grounds,
There
the
was some
petitioners have strongly contended it's without
Decision of
jurisdiction.
the board.
Yes.
Yes, my
So
lord.
the order was passed by the MD, who does not have the jurisdiction to pass the order, my lord.
What do you say?
One of the instructions otherwise says, I'll pass on a copy. Yes. 40 yes, otherwise, it says, my lord, in the Board of Directors meeting held on 9/5/2025, white clause number G miscellaneous 12, it was resolved that Dr. Purnananda Kumar, item 87,
Yes, 5555.
85, 555, General Manager may be issued show cause notice, and in respect of the accountant, no action was,
That is already there.
and no resolution for his suspension was adopted.
There's another line which says, my lords, show cause may be issued and no resolution for his suspension was adopted in the BOD meeting. Clearly, my lords.
This is his instructions. Let him please see it. Why are
Yes.
you snatching it away from
No,
him?
no, that line was not read.
You take your seat.
My lords.
You take your seat. Yes. Tell us.
My lord, as per the instruction, since on the last day, I was asked to fetch
We
the,
want to know,
my lord.
in view of the decision by the board
Yes, my lord.
that show cause notice is to be issued.
Yes, my lord.
His grievance is that he has been suspended.
Yes, my lord.
Number one, by the managing director who is not the appointing authority. And number two, where the appointing authority did not approve of issuing a suspension. What
My
do
lord,
you have to say?
Admittedly, the board of director is the appointing authority that I.
Then have they issued any powers to?
No, my
delegate?
lord. Not as per my understanding.
Then the suspension has to be stayed.
Yes.
Is not authorized.
Well, I will bring it on.
Heard Mr. On talk, the counsel for the petitioner, and Mr. N. Chaudhary, appearing for the which respondent?
For 2 to 4, my lord, 2, 3 and 4.
2, 3 and 4.
Yes, ma'am.
Who's for 1? Veterinary.
Yes, ma'am.
Jay Goswami was appearing on the last occasion.
Mr. Yes, you are appearing.
I appear on behalf of Standing Council of Animal Husbandry of Veterinary.
What is the name?
Name MM
Standing
Kutubi.
Council.
MM Kutubi. Respondents 1,
Ma'am,
2,
One. Is number 1.
1.
The petitioner is aggrieved by the fact that, where is the impugned order?
My lord, the impugned order, page 63.
That by order dated 22/08/2025, the managing director of the Assam Livestock and Poultry Corporation Limited issued an order suspending the petitioner with immediate effect under Rule 6(1), the Assam Services Discipline and Appeal Rules 1964. So, the counsel to the petitioner submits that in terms of the, where is that constitution or articles?
Page 83, my lord. The articles of association of the company, my lord.
In terms of
Additional
the
affidavit, page 83.
additional
Relevant portion,
affidavit.
page
Which additional affidavit? I have additional affidavit.
filed in 5555 minutes on record minutes.
In the referring to the article of association of the corporation, is submitted that the board, it is the board of directors who is bestowed with the power to remove, to appoint at their discretion, remove or suspend any of manager, secretary, officer, clerk, and servants for permanent, temporary, or special services. So, the counsel for the petitioner submits that, therefore, it is the board who is the competent authority, who is the and is the appointing authority, who can place the petitioner under suspension and not the managing director. So, that apart, he submits that the decision was taken at the board to issue a show cause to the petitioner in respect of a matter which was placed before the board, and no decision was taken to suspend the petitioner by the board. So, when the matter was listed on 19/9/25, this court permitted the standing counsel for the corporation, Mr. N. Chaudhary, to complete his instructions. Where Mr. Chaudhary, on the basis of written instructions dated 19/9, has submitted before the court that no decision was taken by the board of directors on its meeting held on 9/5/2025 for suspension of the writ petition. Stop. It is also not disputed by Mr. Chaudhary that it is the board who is empowered to appoint and or suspend the any employee, including the petitioner. So, well, in view of the instructions placed before the court, we permit the respondents to complete their further instructions, if any, and file necessary affidavit within 2 weeks thereafter. Notice issued, not
issued.
Therefore, notice be issued, returnable. Make it 3 weeks. Affidavit after 3 weeks, notice returnable after 3 weeks. The respondents may complete their instructions and file necessary affidavit. This again on 3rd November. In the next date fix, the order of suspension dated
22/8/25.
22/8/2025 shall not be given effect. However, the petitioner, where is that order, impugned order again?
Page 63, my lord.
Where is the show cause notice?
No show cause notice.
However, suspension of this order will not preclude the respondent authorities from issuing any separate orders calling upon the petitioner to show cause on any matter as may be considered appropriate. Stop. The board of directors also is empowered to take necessary action if so advised in terms of the provisions of law.
5531, my lord, he is the accountant. In this matter, he was the general manager, the petitioner was the general manager. Same date, my lord, same.
5555 is general manager.
General manager.
The general manager of the corporation, and
5531.
5531 is the
The accountant, my lord.
And both have been served on the same day.
Same, not served, my lord, it's dated, my lord, 22/8.
Show cause notice dated 22/8.
Suspension, my lord, 22/8/25.
Same date.
Deeply obliged.
Deeply obliged.
David is for order 13/15.
Lord, in this case, my lord, I have implemented, my lord, respondent number 2 and 3, my lord, but no notice has been, my lord, issued, my lord. So, my lord, notice have to go, my lord, to respondent number 2 and 3, my lord. First title, so, my lord, character field.
Issue notice to the newly impleted respondents.
2 and 3, my lord.
2 and 3. Steps by registered force 18 within 1 week from today. Notice is made returnable after 4 weeks. MSRB Bora, IPS 4, respondent 1.
I think 18 and 19.
My lord, 18 is the contempt petition, my lord, which has been filed for non-compliance of the order, which was passed in item number 19. The matters, my lord, both the matters were taken up on 1st of September, where steps were directed to be taken on respondent number 6 and 7, await service report on 6 and 7 and 19, and to take steps upon the contemners in item number 18. You have taken steps, my lord. The office note states that neither AD card nor unserved notices.
Dusty affidavit not filed.
Dusty affidavit has not been filed, but Dusty has been affected on
You have to file.
We'll file it in due course, my lord. In fact, in
Not
item,
due course.
my lord,
You have taken Dusty.
we have taken
service by
Dusty.
Dusty.
Yes, my lord. We
You
are
have been directed to file a compliance affidavit.
my lord, the Dusty was returned to us based on the service on the contemners a few days back, my lord, last week. So we could not file it in due course. We'll be doing it in due course, my lord. In respond number 9, item 19 also, my lord. For respond number 6 and 7, the office note is silent on the service affected on them.
You first file it here.
We will do it, my lord. My lord, if I may
Counsel for
pray.
the petitioner will file affidavit in compliance of the Dusty service stated to be undertaken in contempt petition number 426.
My lord, there's one submission, my lord, I have to make, my lord. In item number 19, the writ petition regarding service on respondent number 6 and 7 who has been arrayed by name citing malafide, my lord, if I may effect the service through my learned senior, Mr. A.K. Dutta, my lord, since he appears for respondent number 4 and 5, which are the posts which are held by 6 and 7. As per the office note, my lord, dated 17/9, neither AD card nor unserved notices have been received on 6 and 7. So if I
Who
can,
are 6 and 7?
6 and 7, my lord, is the administrative officer and the officer on special duty who have been arrayed by name as 6 and 7. If I may be permitted to take steps on them to my learned senior
Right.
friend,
Take Dusty.
my lord, the lordship permits me, I'll take that justice.
Well, in contempt petition, I have filed my color number to
Yes.
And in
You have
other
filed
case,
Wakalanama on whose behalf?
color number on behalf of opposite party 1 and 2.
Then the
Content.
steps are completed. my-
1 and 2.
Uh,
1
in
and 2.
contempt petition.
All right, heard. In the contempt petition, you write, heard Mr. M. Sharma, counsel to the petitioner. As per office note, AD card or unserved notice on behalf of respondent 1 is not received. As well as the Dusty's, as well as the affidavit effecting Dusty service has also not been received. So Mr. A.K. Doctor, learned counsel submits that he has instructions to appear on behalf of respondent 1 and 2. Therefore, service on respondent 1 and 2 as is deemed to be therefore respondent 1 and 2 being represented by the counsel, he is permitted to file his objections. No. So far as the writ petition is concerned,
My lord, in this case, my lord, I filed an IA, my lord, for modification of the interim order. IA number 2959 of 2025.
which order?
At page 21, so far as the silk cover is concerned, my lord. 24, my lord. Page 24. This is an interim order, and the relevant portion at
Wait,
28.
the
my lord.
BPC 4027. The 4027 also you appear for 6 and 7.
4027, IA 2959 of 2000.
In the writ petition, who do you appear for?
I am appearing.
In the writ petition,
Yes.
do you represent any respondents?
My lord, for the institute, LGBRMH.
Only for the institute.
Yes, my lord.
Have you seen the response? Do you have a copy of the writ petition?
Yes, my lord.
Please see respondents.
Jyoti Hazarika and Hemanta Dutta. 6 and 7.
My lord, in the repetition, my lord, union up to respond number 5, administrative officer. I am.
Six.
I filed this.
Please listen to the quote. 6 and 7.
Six and-
Respondents 6 and 7 are respondents 1 and 2 in the contempt petition.
Yes, my lord.
So you are instructed to appear only in the contempt petition, not in the writ petition.
Writ petition, I am also appearing.
That is what we are asking you.
I am appearing.
Yes, Mr. A.K. Dutta, learned counsel represents all the respondents. The writ petition. In the
My
IA,
lord, I am, my lord.
issue notice.
24, my lord. Page 20.
IA is filed by the secretary. Who has filed the IA?
Responder 225. my lord.
Secretary, Ministry of Health and Welfare, Government of India, Chairman, Executive Council, Lokopriya Gopinath Bordle, Regional Institute of Mental Health, Dashboard. So the petitioners of the applicants have filed this IA seeking modification of the order dated 23/7/2025, passed in WPC number 4027 of 25. There, issue notice returnable 3 weeks. Mr. N. Sharma represents the respondents
My lord, in this,
of the party writ petitioner. Therefore, notices are waived. Extra copies of the IA be furnished within 1 week from today. Objections, if any, may be filed. Matter be listed in the last week of October. Yes. The AC2 fees is one.
We have filed an IA challenging the appellate authority's order dated 08/01/2025, whereby the petitioner was subjected to undergo compulsory retirement. And also a so-called notice was also issued against the petitioner.
What have you challenged in the writ petition?
That was the earlier order. Meanwhile, we have filed this appeal in the earlier writ petition. We had challenged the impugn order. Meanwhile, the appeal was pending before the appellate authority. So they have now this we are in this IA we are challenging the impugn order, the latest one, the appellate authority's order, along with the so-called notice.
This IA arises out of the writ petition.
Writ petition.
In the writ petition, there is no challenge made to the appellate authority.
They will,
Then
at the
how
time,
you can do it by an IA?
at that point of time,
It was not there, you file a separate writ petition if required.
at that point of time, the appeal was pending.
They have been pending, but now it is disposed of. You want to challenge this order also. Yes, what do you say?
My lords, subsequently, my lord, the appellate authority has issued the order. In fact, there is, in the writ petition, there is a prayer also to the effect that the direction may be issued to the appellate authority. That has been done, my lords. A subsequent order cannot be challenged by way of an IA, my lords.
You either modify this writ petition or you file a separate writ petition. How you are challenging it by way of an IA?
Pray for modification of the writ petition.
And the request made by the counsel for the petitioner, matter stands deferred. Permitting him to take steps for modification of the writ petition to incorporate the challenge made to the order passed by the appellate authority in the appeal preferred by the writ petitioner, which ultimately came to be rejected. Let this modification steps be taken for amendment of the writ petition be undertaken within a period of 3 weeks. Yes, sir.
May I please, Your Lordship? On last of the Your Lordship, notice was issued. We have taken steps in respect of the last order. But Lordship, notice upon the pro forma respondents were also issued. Perhaps that may not be required, Lordship, because we have not sought any relief against the pro forma respondents. And if Your Lordship carries this for a moment, order dated 26/6. 26 June, 26/6.
Who are the pro forma respondents?
They are the juniors of the petitioner.
Huh?
They are the juniors to the petitioner.
Then how is the pro forma respondent? You are
Because
challenging your
no,
selection.
no, Lordship.
What are you challenging?
Lordship, promotion of the petitioner from ACF to DCF.
That's right. They were juniors, they were promoted earlier.
Yes.
So you have to challenge somebody's promotion to
No,
see.
we have not challenged their promotion because there are posts still vacant. So,
Maybe, but then even if you are promoted, supposing this writ petition is allowed,
Lordship,
are you saying that you are going to forego your seniority claims?
Lordship, our issue is that Lordship, the APR, annual property return letter at page 21, that was not furnished to us. So we could not submit our APR within.
What is your grievance here? You are seeking a direction to the respondent to promote
Lordship,
in the next eligible post.
Lordship,
But your juniors are already promoted.
Lordship,
So the juniors in the feeder category have now become your seniors.
Lordship.
So when you get promoted, assuming we allow the writ petition, are you saying that you're not going to reclaim your seniority?
No, their seniority will not be affected, Lordship.
We'll record it then.
Lordship.
Think about it before you make submission. You're sure?
Otherwise also, Lordship, they have to file their affidavit. So let them file their affidavit,
You are making a submission that you don't want to take steps on the pro forma respondents.
we have already taken steps upon them.
Then,
But we have not sought any relief against them, Lordship.
that is what we are asking you.
Lordship,
If you are asking a direction for promotion,
Lordship.
assuming the writ petition is allowed, are you foregoing your seniority?
No, Lordship.
Then,
Because we have claimed a promotion with retrospective effect.
then how are they pro forma respondents?
Because we have not claimed any relief against them.
Don't make submission without reading your brief. Read it properly, understand what is the matter about, and then come and submit. Don't waste time on the court. If you're not prepared, take time to read your brief.
Let them file their affidavit.
List after 3 weeks.
Lordship, let the department file their affidavit.
You tell us, we can direct that, provided we record that you are not claiming any relief or in respect of the seniority of the pro forma respondent. We'll record it. You want us to record it, we'll record it.
No, Lordship.
Then you are saying that you are not claiming relief against the private pro forma respondents. Yes,
Yes.
we'll record that. Then we'll direct them to file their affidavit. But we'll record it first. You make up your mind.
Lordship.
We are giving you 3 weeks to make up your mind.
Lordship.
Yes. After 3 weeks. Mr. Reporter will go the respondents. Yes.
Maybe lost. So operational data 19/9/2025 it says that we have taken step lost. Accordingly, lost the indication of decision number 6 has already come up. And regarding lordship 4 and 5 lordship, it said that the item is delivered lordship as per postal report lordship.
Yes.
Your lordship, I'm appearing for respondent number 5 and 6. We are going to file our affidavit today, your lordship, along with affidavit in opposition also.
Who is for respondent 1 to 4?
I appear for respondent number 2, Justice Department.
Then 1 and 3.
One is some GCS. Yes, lordship, they also appeared lordship. Already last time official there.
Who appeared?
Mr. K. Gogoi was appeared last proposal lordship. Only now last.
Mr. K.
Gogoi.
Yes, sort of parties. Your MS?
K. Sharma, your lord.
K. Sharma represents respondent number
5 and 6.
5 and 6. Submits that the affidavit on behalf of respondent 5 and 6 will be filed during the course of the day. Sure.
Not course of the day, your lordship. We are going to file our Vakalatnama during the course of the day.
Vakalatnama.
Yes, lordship. And in the meanwhile,
Submits that she has received the power to represent respondents 5 and 6. And the same will be filed during the course of the day. She prays for 3 weeks' time to complete instructions and file the affidavit. Similar prayer is made by Mr. D. Bora, representing respondent number 2, as well as the council representing respondents 1, 3, and 4. Let this matter be listed.
Lordship,
Again.
4 not appearing, lordship. 4 perhaps it is remaining, lordship. 4.
Hmm?
Yeah, up 1 to 3 lordship already appeared, lordship. 4 is remaining, lordship.
Who is 4?
4 lordship, T Research Association lordship, and it is said lordship, they received the copy lordship, but they have appeared to the lordship. Lordship, we have to also take another step, lordship.
1, 2, and 3.
Yes.
As per office note, service on respondent 4 is complete. However, none represents the respondent number 4. Stop respondents are permitted to complete their instructions and file necessary affidavit. List again after 4 weeks. Matter be listed on 7th of November till the next date fixed. Interim order passed earlier will continue.
My lordship. As reflected in the office note dated 19/9, as per the postal report, items have been delivered, lordship, on the private respondent. As per the postal report, service seems to be delivered on the private respondent, lordship. So
As per office note 19/9, service on respondent 215 is shown to be delivered within courts as per the consignment report available on the India Post within courts website. However, none represents the said respondent. Mr. P.P. for
Respondent 4, 5, 6, and 7. Standing counsel appears.
4, 5, 6, and 7 appearing. The MPSC, Mr. T. Ghosh for
A push for
A.
1, 2,
Ghosh
and 3.
for
1, 2, and 3.
1, 2, and 3. Have you filed your
Lordship.
affidavits?
No, lordship, I have filed within
The
4
respondent
weeks.
counsel seeks liberty to complete their instruction and file necessary affidavit. List again after 4 weeks.
Publish.
May it please your lordship. My lord. On 6/10/2023, 5,500 plus for constable posts, applications were invited. Interview of physical test, physical standard test, physical eligibility test, and medical test was done in October 2024. After doing that, my lord, in the month of March, my lord, result is declared, and what happened, my lord, as per clause 12.5 of the advertisement itself, my lord, result should be declared, merit should be published, and it should be 1:5, my lord. Against one post, 5 person is to be called for written test. Number one, my lord, it is not done, my lord. No list is published, no consolidated list is published, no merit list is published, my lord. And my lord, in place of maximum limit of 50% of reservation, it is made 62%. So far as I understood, subject to correction by your lordship. My lord, thereafter, my lord, what happened?
IA for what?
IA, my lord.
IA for, my lord, at this stage, my lord, we have come to know that they are going to appoint anytime, my lord, from the select list, my lord, without publishing the merit list till date. Nobody knows, my lord, how I am got, my lord, not selected, and how X and Y are selected, my lord.
The select list will only give the roll numbers of the person selected.
My lord, it was, my lord.
It doesn't describe how the other.
My lord, what is that, my lord? Only kindly let us look at the page number of my IA, my lord, of IA number 3157. Page, my lord, 72, my lord. 71, my lord. This is the format of getting the result, my lord, from the online, my lord. Below, my lord, kindly see, enter your roll number, enter your date of birth.
By the earlier order dated 4/4/25.
Yes, ma'am.
Court has already held that selection made shall be subject to the outcome of the writ petition.
My lord, exactly, my lord. At that point, what happened, my lord? I prayed for on 6th, it came up on 4th, and on 6th, there was a written test, my lord. So I prayed for stay of the written test, my lord. Court said that at this stage only 2 days remain. They have arranged everything. So we are not going. Now they are going to appoint, my lord. And
Maybe, but their interim prayer is already rejected, granted.
my lord,
You are asking for another interim prayer.
my lord, at that stage, my lord, only for my prayed for stay of the, my lord, entire process, my lord.
That interim prayer has already been granted.
And
4/4.
my lord, subject to, my lord. Going to subject to.
That is an interim prayer.
my lord, but now at that stage, my lord, there was no my lord, possibility of appointment and selection, my lord. So I only prayed for that part, my lord, only. And at this stage, it was done.
There that your appointments, whose appointments are selection process undertaken shall be subject to the outcome of the writ petition.
My lord, when other order is mentioned also at this stage, it is not being granted, my lord. There is 2 orders in 2 petitions, my lord.
Who's for the respondent?
I am, my lord. My lord,
What is this selection about?
my lord, the thing is that he has filed a now IA. I have to, my lord, seek instruction from the authorities, my lord. And earlier occasion, my lord, there is already an interim order granted. And if he wants a modification, he has to file an IA for that.
On 16(9),
My lord.
what is the matter about?
My lord, kindly turn to page, my lord, page 55, my lord, of my IA, my lord. My lord, there is IA only for, my lord, at least to defer the issuance of, my lord, appointment letters, or to, my lord, to keep 200 posts vacant for us. Similar, my lord, in other case, my lord, 2 posts are kept vacant already, my lord. Similarly, prayer was there and 2 posts kept vacant, my lord. I have annexed in the main petition also, my lord. My lord, there were two petitioners, my lord. For them, 2 posts are kept vacant, my lord. So, my lord, similar prayer, at least, my lord, 200 posts out of 5,500 plus, my lord, may be kept vacant, or, my lord, some deferment of, my lord.
How many petitioners are here?
My lord, 110 plus 90, my lord, 200. 200.
How 200 posts can be kept?
My lord, out of 5,500, my lord.
My lord, it may be.
My lord. My lord, kindly see, have a look, my lord, at clause 12, my lord. How they have violated directly, my lord. Total violation, my lord.
My lord, we will answer, my lord.
Council,
They have already applied. File,
by order dated 4/4/25, there was a direction that it shall be subject to the outcome of the writ petition.
My lord.
You should have got the matter heard.
My lord, the
Instead
matter.
of waiting for an IA to be filed today,
My lord.
just before the holidays, to put a stay in the entire selection, where your prayer has already been granted.
My lord, what happened, my lord? The entire proceedings is complete, my lord. Matter is fixed for hearing on 24th, considering the urgency. Day after tomorrow, my lord. But now the hearing matters are not being taken at this stage, my lord. So, my lord, in the meantime, if they appoint, my lord, we will be in a serious complication. We have to issue notice to, my lord, notice
No,
to
my
all
lord,
5,500.
outcome of the writ petition, my lord.
5,500 to go, my lord.
This court can always stand back, my lord. Since there is a direction,
My lord,
it will be the outcome of the writ petition, my lord.
We have to file notice to all, my lord,
And that
5,500
order is
plus.
still standing, my lord. That order has to be modified first, my lord, through an IA.
Third party interest will be created very soon, my lord. Once the letter is issued, my lord, the third party will be created, my lord, interest will be created, my lord. We have to file, my lord, IA for serving notice to all, my lord.
What is the ground for challenge?
My lord, ground for challenge of violation of, my lord, kindly turn to page 60 of the IA, my lord.
No, in the writ petition, tell us.
Yes, my lord. They must say, my lord, my lord. My lord, kindly take the second one, my lord, 3172 WPC, my lord. Once the letter is issued, my lord, there will be inordinate delay, my lord, in my lord.
Yes, tell us.
My lord, can I turn to page 49, my lord?
49. Yes.
My lord, this is the advertisement started, my lord. Now, my lord, for the posts of 5,563, my lord, with some, my lord, different categories, my lord. Now, my lord, kindly turn to page, I'm going shortly, my lord, very short, page 58, my lord. Page 58, my lord, Roman 12, clause Roman 12 of the advertisement, my lord. And sub clause 5, my lord. That is a very important, my lord. May I read, my lord? All the candidates will be subjected to biometric recording. Sorry, 5, my lord. Candidates shall have no claim or right to appear in the written test merely on the ground that they secured minimum qualifying standards in PST and PET.
After you're reading from where?
My lord, page 58, my lord, WPC 3172, my lord. Second petition.
3172.
Page 58, my lord. My lord, Roman clause Roman 12, my lord. 12.
Yes.
Sub clause 5, my lord. Roman 5.
Yes.
My lord, candidates shall have no claim or right to appear in the written test merely on the ground that they secured the minimum qualifying standard in PST and PAT. After completion of PST and PAT, for all the candidates, merit lists of each category as per vacancies shown at para 1 above will be prepared. My lord, this is not prepared till now, my lord. And on the basis of the total marks scored on PAT, converting into percentage, candidates will be called for the written test in order of merit at the rate of of 5 times of the number of posts allotted. That is the point, my lord. They have not, my lord, called for 1:5, my lord. It is almost an admitted position. They have filed the affidavit in opposition. Wherefore, it is clear from the count, my lord, at least 2,000 posts still to be called for, my lord, as per their own count, my lord, given the affidavit in opposition, my lord.
Where is that evidence?
Yes, my lord. Kindly take the, my lord, the affidavit filed by the in 3172, my lord.
Hmm.
Kindly turn to my lord, paragraph page 229, paragraph 8, my lord.
Yes.
My lord, there is paragraph subpara 2, my lord, a total of subpara 2, my lord, a total of 22,214 candidates had been shortlisted for written test against total 4899 posts based on merit on PET marks as per the results uploaded on 12/3/25. There are certain post category where total number of PET qualified candidates were less than 5 times of post. However, a rectification process was conducted, my lord. Here one thing, my lord, we have filed objection. After filing the representation objection and protest marks, my lord, then they corrected.
What is your ground for challenge?
That is, my lord,
What?
that 1:5 is not maintained. Merit list not published, my lord. Merit list has yet not been published, my lord. And 1:5 not maintained, my lord. I kindly.
How do you say that? On
Yes,
what
yes,
basis?
yes, my lord. Kindly take my affidavit in opposition, my lord. Filed in 1902. Kindly take it, my lord.
But 1902.
1902.
No, we are not inclined to grant you any stay.
My lord, kindly see, my lord, para 7, my lord, page
No, no.
257, my lord.
Bare statement will not do.
No, I have given the statistic account, my lord. Kindly
Yes,
see.
yes.
Kindly see, my lord. Paragraph 7, page 257, my lord. Of my affidavit in opposition, my lord, which is a common affidavit, my lord, in both the cases, my lord.
Then why did you take us to the other writ petition?
My lord.
If it is a common affidavit.
Oh, my lord, on last occasion, my lord, when the court asked me whether to file in another affidavit in opposition in the second case, being the same similar issue, my lord. And
Yes,
being
yes, come to your
yes, my lord.
affidavit.
257, my lord, kindly see. As per the that as regards the statements made in paragraph number 9 of the affidavit in opposition, the petitioners begs to state that a simple and plain reading of the paragraph reflects that the state respondents has indirectly admitted the fact that in the process of selection of candidates for written test, it has clearly violated the mandatory provisions of clause 10(5) of their own advertisement itself. As per the advertisement, it is stated that a total of 22,000 aberments made, my lord, 22,214 candidates had been shortlisted for written test against a total of 4899 posts based on merit. Now, if the 5 times of number of candidates against the total number of 4899 posts is called for, as per the mandatory provisions of clause 12(5) of the advertisement, then 4899 into 5 is equal to 24,495. So altogether, 24,495 candidates ought to have been shortlisted.
Where
And
is
called
that
for.
advertisement again?
My lord.
Advertisement. Clause 12.
Clause 12, yes, my lord. Clause 12 is, my lord, in my lord, IA. In IA, it is at page. At page, my lord, relevant part is at page. (170). 3170, 3150, 3172. Let me check. My lord, at page 55, my lord.
What about the PET and the PST test?
My lord, physical eligibility test, physical standard test, medical
Yes.
test.
You have cleared.
We have undergone, but our marks are a bit fraction below than they have fixed the marks later on. They have fixed the cutoff marks later on. Twice after
Have you
objection,
cleared PST, PET?
we have cleared. But what is that happened, my lord?
How have you cleared if you are below the cutoff mark?
Yes, my lord. Their cutoff mark is fixed later on. That is also illegal, my lord. They have made far later, my lord, their cutoff marks. After objection, they have changed the cutoff marks again, my lord. That was happening. And main thing is that, my lord, till day, 1:5 merit list is yet not been published. Only a single person can see his own result only, my lord. Nobody can see the other's result, how he has got not selected.
Exactly,
or
my
how he
lord.
has not selected.
These are
Why are you concerned?
these are confidential issues, my lord.
My lord, I have a right to know, my lord, how I have, like in on.
My lord,
everything.
if
You
he has
have
a
a
right,
right to know, you file your application.
he has to file a RTI, not
File
for my lord.
application
My
to
lord,
the authority.
my lord, in their own advertisement, they have said that merit list again and again, my lord. They have in the FBT in opposition also they have said merit list, my
Merit
lord.
list is for my lord
But
administrative
where is the
purpose,
merit
not
list,
for
my
my lord publication in
not even
in
placed
the
before your
public
lordship,
domain,
my
my
lord.
lord.
I have a prayer in the mediation, my lord, to place it before your lordship, before the court, my lord, the merit list. Still,
Why should we be interested to see the merit list for what? To help you build up your case?
my lord,
That's not the purpose of.
and my lord, kindly see, 1:5 is a mandatory provision, my lord. And kindly see, as per their own affidavit, my lord, they have not maintained it, my lord. And they have not done it, my lord. Had they been maintained, we would have been entered, my lord. Only we have 200, my lord. There are 2,000 yet to be called for as per their own statement, my lord.
My lord, they have
If it is to be believed, my lord.
filed an IA, my lord, will reply, my lord.
So we are only for that, my lord. At least 200 posts may be kept vacant.
Party issue notice in the IA. Mr. R. State Council represents all the respondents. Therefore, notices are waived. You are representing all.
My lord.
Therefore, notices are waived, extra being furnished within 2 working days. The IA be listed immediately after the reopening.
After, my lord,
Reopening
till then appointment will be over, my lord.
can be helped. We'll see.
My lord, at least 200 posts, my lord, kept vacant, my lord. Similarly, my lord, 2 posts are kept vacant, my lord. I have to annex the order also, my lord.
No.
In similarly cases, my lord, 2 posts are kept vacant, my lord.
What is the point in keeping 200 posts? We'll ask them to keep the entire selection at bay.
Yes, your lordship can.
Why should
But my lord, once the appointment is issued, my lord, we have to serve notice upon all of them, my lord. 5,000 plus,
the
my lord.
notices were issued in your writ petition in April. You are urging urgency today.
My lord, at that point of time, they said it will be deferred, my lord. They said they will publish the merit list.
You have come to the court.
And we have filed.
Come to the court. You have been sitting over the matter for the last 4 or 5 months.
My lord, we have filed that in opposition. They have filed, we have filed it, my lord.
Hearing if
Every
required.
reply, my lord. Pleadings are also complete, my lord. Pleadings are also complete, my lord.
Immediately after reopening, we'll see.
My lord, till then, my lord.
No.
Appointment
Not
should
like
be over.
this. Not like this. Not like this.
They have
you
not
show us materials to show.
Yes, my lord. My lord.
This is your interpretation.
No, my lord. This is proved
This
fake,
is
my
your
lord.
interpretation.
My lord, kindly have a look, my lord. Kindly have their own my lord, their affidavit, my lord, and my affidavit, my lord. I have clearly mentioned, my lord, how they have missed the, my lord. They have calculated wrongly, and they have missed 2,000, my lord.
First, in the writ petition itself,
My lord.
your interim prayer is granted, making it subject to the outcome of the writ petition.
My lord, at that time I paid
You are
for
not agreed by the order.
to stay the
You are not agreed by the interim order. You
My
did
lord.
not go in appeal. You did not pray for review.
My lord, I at this
Then-
I actually I paid for stay of the
You
operation
can't
of the
keep
test
on-
report, my lord, test, my lord.
Keep on asking for interim orders after interim orders. It was open for you.
My
You
lord,
did not press it.
my lord, in the second case, my lord, it is clearly mentioned at this stage, considering the date fixed, my lord, on day after tomorrow, we are not giving the interim.
Whatever.
So, my lord, that's why, my lord. And here in the affidavit, my lord, their affidavit, my lord,
We are not
clearly
inclined. We are
2,000
not
posts are.
inclined. We are issuing notice at this stage. If you want, we'll hear and pass final orders in your IA if you want. At this stage, we are only issuing notice.
My lord, on 24th for hearing fees, my lord, can it be disposed of on that day, my lord? Maybe
24th, it cannot be disposed of because you have filed an IA, we are issuing notice.
Yes,
How on
well,
24th?
if it is disposed of, then
24th
IA will be, my lord, will become
24th
infractors.
of what?
We will not press for
October.
IA anymore, my lord. If the
24th of October.
this 24th, my lord.
How it can be?
That's why, my lord, if it is disposed of here, fittings are complete, my lord.
Ah.
Simple matter, 2 issue only, my lord. This
No, no,
1:5,
all
1:5.
Then we are not issuing notice. Then we are not issuing notice in your IA. Why should we issue notice in your IA if the matter is to be listed for hearing on 24th?
If your lordship, my lord, that's why I'm praying for my lord.
It is up to you. You tell us what you want. You want a hearing on 24th, we'll take up a hearing on 24th, but we are not issuing only the interim prayers.
Maybe taken together on 24th, my lord.
No,
Then, my lord, your lordship will decide, my lord, whether.
we have already decided. We are giving a returnable date after 3 weeks. File your response, if any. Yes.
Oblige, your lordship.
Your lordship, we have filed it on Friday, last Friday, this 19th.
What have you filed?
Affidavit in opposition.
matter relating to
It is
dismissal.
submitted by the counsel for the petition that,
May I please, your lordship? Lordship, I'm for the petitioner. They've recently filed their counter affidavit. We require little time, your lordship, to file our reply. Lordship, may kindly take up this matter on
counsel for the
20.
petitioner submits that counter affidavit has been filed by the respondent. They'd like to file a reply affidavit. They'd like to file their reply. List again. After
On 29th of October, your lordship.
29 of
Deeply obliged.
25.
Kindly peruse the order dated 19/7, my lord.
yes.
The honorable court directed to receive complete instruction. The matter regarding non-payment of my lord, retirement benefits, my lord.
Yes, Mr. Moore.
If your lordship will file affidavit.
How much time do you require?
2 weeks time.
2 weeks.
My lord, already two occasions, my lord, checking time. my lord.
Praise for 2 weeks by the time they file his affidavit. Mr. Pierre Partiri appears for the petition. List again after.
That may be next 6, my lord.
24th
My lord.
October.
My lord.
It's not-
Obliged.
Obliged.
May I please, your lordship? My lord, this case is a very pathetic, my lord. Despite of several orders, I am suffering from cancer, my lord. I could not go for treatment. On the last occasion, they said, my lord, some amount has been given, but it reveals, my lord, while
Yes,
I was.
honest.
The affidavit has been prepared and it has been sent for vetting.
We are not there. We want you to tell us why we are holding on to the pensionary benefits.
Lordship, the area salary and provisional pension has already been released. So
No.
that also we are bringing on record in the affidavit.
Your affidavit will not come in these 1 or 2 days.
Lordship,
My
just
lord,
one
at
week.
least, my
just
lord,
one-
interim, my lord.
Then you are, by default, you are getting 2 weeks further time.
My lord, as a interim prayer for my treatment, my lord, leave encashment, gratuity and group insurance be given to me, my lord, so that I can proceed with further treatment.
You get your instructions by Thursday.
Lordship,
Some orders will be passed. If you don't get it.
Lordship.
Mr. J. I. Borboya, counsel for the petitioner, MS M. Polital and counsel representing the forest. He is permitted to complete instructions as to the release of what?
My lord, leave and interim, my lord, I am asking, leave encashment, gratuity and group insurance.
Leave encashment, gratuity and group insurance respect to the petition.
As an interim.
Considering the petitioner is suffering from cancer
My lord.
and he is in need of urgent treatment. Mr. D. Bhattacharya appears for respondent 5, the accountant general. List on Thursday.
Yes, sir.
Obliged, my lord.
May I beg your lordship? My lord,
You wanted some time.
Yes, sir.
You prayed for some time.
Yes, my lord, matter can be taken after vacation.
Yes.
We have no objection, but the thing is that the disease of the lead petitioner, he was a casual employee. We'll have to see whether casual employee is entitled to such benefit or not.
Not casual employee, but he was regularized subsequently, Initial appointment was in 1999.
Counsel, you have to file your response. Have you filed your?
Yes.
The respondents are permitted 2 weeks time to file their affidavit. Mr. A.R. Counsel appears for the recognition. They start
Yes, sir.
2 weeks.
Acha. Obliged.
May I plead, Lord? Reinstatement petition, Your Lordship. I was in this case followed by my trivial case. Instruction was sought on last.
Lordship, we have not received extra copies here, Lordship.
Sir,
It's not there. in the-
You serve.
I'll give it by today.
Counsel for the petitioner undertakes to furnish extra copies. And to the respondent counsel list again after 3 weeks. MSU shall write case for the respondents.
1 to 4.
One.
Right. Ma'am, please, your lordship. My lord, here is the case, my lord. Petitioner, she retired on 31/7/23. And impin order has been passed at page 63. Keeping, my lord, page 63, last paragraph. That the governor of Assam pleased to impose penalty withholding, incrementing cumulative effect. And thus the departmental proceeding draft so and so is disposed of. I got retired. How, my lord, cumulative will come from which date, when, how, nothing has been made.
What about your affidavit?
My lord, I'm seeking one more opportunity, my lord, for instructions. Yeah.
You have been granted 3 weeks time.
Several times, my lord. So till then, my lord, impin order may be stayed.
What is your grievance here?
Grievances, my lord, I am challenging basically, my lord, page 63. An impin order has been passed on 30th April 25, stoppage of my one increment on cumulative basis without mentioning date, when, how, when it will be affected. And I got retired, my lord, 31/7/23. After retirement, my lord,
After retirement, the order was passed.
passed, my lord. That too, my lord, on 30th April 25. I retired on 23. As a result of this, my lord, my all pensionary benefits got held. So I prayed before your lordship by instant writ petition, my lord, challenging the said communication order dated, as well as, my lord, all consequential relief, my lord. So as to get my retirement benefits. So since, my lord, that did not turn up, so I pray before your lordship, the operation of impin order at page 63 be stayed, my lord. Seems to be, my lord, issued without application of mine, my lord.
No, as on date, what is the effect?
In fact, my lord, I did not get, my lord, provisional pension, anything for which I filed another writ petition. That is at item number,
You are challenging the imposition of penalty.
my lord. That's why, my lord, I pray before
What is
lordship.
it? On what ground?
My lord, this cannot be an impin order in the sense, my lord, after retirement, from when, my lord, the cumulative account will count. No date, nothing, from when it will affect, how it is being affected after retirement. I am not getting salary after retirement. No question of increment does not arise. So this order was issued.
How has it affected your pension now?
My lord, they have all stopped it, my lord. Even provisional pension also stopped, nothing has been, my lord. What I
Provisional-
pray before your lordship, my lord, this impugn order may be stayed, my lord, till they file an
So
affidavit.
how does it benefit you?
My lord, at least I can hesitate before the authority, my lord. Because the other provisional pension, lordship fixed the matter on Thursday. As item number 2
Hmm?
of today's list, my lord.
Hmm.
I'm asking for a provisional pension,
With the same petitioner.
same petition.
So have it on Thursday.
Thursday.
Yes,
You get his grievance is that your penalty imposed is withholding of 1 increment. Which increment? He's already debited office.
number quite.
His order is passed after his retirement.
447.
Clarity is required, my lord. Otherwise, on the face of it, the order lacks reason. I'll take instruction Thursday. It may be fixed with
No,
the.
you take instructions to the effect that whether this penalty at all can be imposed,
My lord, that is.
not from which
Yes.
date. Counsel for the respondent is permitted to
along with you.
complete instructions on the penalty imposed by the order dated 30th of April 2025, as it is submitted that the similar matter is filed by the writ petitioner is fixed on 25.
My lord, I'm giving the number, my lord.
So accordingly, let this matter also be listed on
Double-
25, 9, along with WBC.
4478/25.
4478 of 25.
आपके आ देखो हाँ दोबारा पढ़ो
May this lordship, my lord, notice was issued on interim in this matter. If your lordship not intervene with the grievances of the petitioner will suffer injustice. Therefore, the petitioner is here, my lord.
What
Seeking, interim,
injustice?
my lord.
What injustice have you suffered?
My lord, petitioner was serving in the office of chief engineer, water resource department. While the petitioner promotion was on due, the department has transferred him to the office of district executive engineer office, where the services were governed by different set of rules, my lord. Therefore, there is
He was working as
senior assistance,
in the office of
chief engineer, water resource department,
and he was transferred to
executive engineer. The transfer order is page 25, my lord, Annexure 7. And respondent numbers 4 was transferred to chief engineer, who was serving in the office of executive engineer, my lord. There is a malevolent intention of the petition of the respondent transferring the petitioner to the another district level.
What is the next promotion you are seeking?
Superintendent, my lord.
Superintendent.
Yes, my lord. My lord, lordship, may kindly see page number 22, Annexure 4. This is the final petition list of senior assistants in the office of chief engineer, my lord, where the respondent is placed under serial number 3. Here, serial number 1 and 2, they are already promoted to superintendent. Right order to,
And in the present place of posting, what is your seniority?
my lord, as in the
Chief
present,
engineer's office, what is your seniority?
in the present post, and in the chief engineer,
Not chief engineer. You are transferred from.
executive engineer, my lord.
Ah,
In the executive engineer, my lord, the next senior post is
Yes, PHE.
My lord, I have appeared for the respondent number 4 today.
supervisory assistant, my
I
lord.
am going to submit affidavit, my lord, after 2 weeks.
Yes. PHE. Lots of water issues. Water resources.
Lordship, his promotion won't be affected. If there is post, we will, that is our instruction, we will promote him. That is our instruction.
My lord, not that it's a transferable job. However, without considering the case of the petitioner, if the respondent they have proceed with the promotion, then like
So how
petitioner will
are you
suffer.
giving effect to the promotions? How are you giving effect to the promotions?
Lordship, promotions. Now post is not available for promotion, Lordship. That is my instruction. Actually. So he won't be promoted now, Lordship. No
In the,
post.
my lord, in the office of chief engineer, one of my senior who is placed in serial number 2, serial number 1, he will be retired on 30th November 2025. So this is the petitioner have a presumption that like he will be next
Now the
eligible person to be promoted in the next roles.
private respondent who has been
My lord.
transferred in your place.
Yes.
What will be his seniority position in the chief engineer's office?
Supervisory assistant, my lord, as per the Assam Administrative District Establishment Service Rule.
Kapu page 22.
My lord.
This is the seniority list.
Yes, my lord.
You are at serial number 3.
Yes, lord.
Your claim is that serial number 1 will retire.
My lord.
So there will be a post of senior assistant or superintendent vacant.
Vacant, my lord.
So you being senior, you should be considered.
Yes, my lord.
Now what is the position of the respondent 4 pursuant to the transfer order?
Because even respondent is transferring is also a senior assistant.
In your place?
Yes.
He will occupy your
Yes, my lord.
seniority.
Yes, my lord.
My lord,
Page number
my lord,
25.
I have been
Yes.
transferred as per the due procedure of law by government has transferred me. So I have not submitted any application that I may be allowed.
We are not saying that. We are
That
asking
I want
you,
to.
what
My
will
lord,
be your seniority in the chief engineer's office?
my lord, I am transferred by the department. I have joined there. I want to submit affidavit, my lord, with as per instruction. After twist, my lord,
parties.
then it will be clear, my lord.
Mr. C. Sharma appears for water resources. And Mr. S. Sharma appears for respondent number
4. Respondent 4.
Mr. Sharma, S. Sharma submits that he'd like to file his affidavit as he is being instructed to appear on behalf of respondent number 4. So, counsel for the petitioner on the other end submits that submits referring to the seniority list and goes to the writ petitioner. The office of the chief engineer, water resources department. Annexure 4 within bracket. It is submitted that prior to his transfer, petitioner was at serial number 3. And the person at serial number 1 and 2 have already been promoted to the next higher post of superintendent. Therefore, the petitioner, being the senior most, was the most eligible candidate for being promoted to any further vacancies that may arise in the post of superintendent. Yeah, under the office of chief engineer, water resources department. So, however, by the impugned order dated so and so. Where is the impugned order?
Page 25, my lord.
Page 20.
Annexure 7.
Dated
3/2/2025.
Annexure 7. Petitioner has been transferred to the office of senior assistant in the office of the executive engineer, Rural Water Resources Division. And private respondent number 4 has been brought to the place of the writ petitioner. The learned counsel for the petition therefore expresses apprehension that in the event the vacancy arises, the petitioner, the private respondent number 4 will be considered for the post of superintendent under the office of chief engineer in place of present petitioner, notwithstanding that the petitioner prior to his transfer was the senior most eligible candidate. So there are counsel for the respondents pray for submit that they would like to file their necessary affidavit. Stop. the Standing Council Water Resources on the other end submits that the apprehension by the petitioner is not well founded in the event of any vacancy of superintendent being available in the office of the chief engineer, petitioner, along with all other eligible candidates, will be considered for such vacancy. Let the matter be listed immediately after the 27th, 27 October. Yes.
Beg your lordship, my lord.
May I please, Lordship? I have received instruction. I would like to file in affidavit, Lordship. Kindly grant 4 weeks time, Lordship.
Yes, Mr. Raman.
Yes, my lord, today this matters fixed for interim prayer for family pension, my lord. I have not been paid family pension, my lord. Your lordship is very well aware of the on last occasion I presented this with your lordship.
Why are you
Yes.
paid family pension? Why?
As per our instruction, Lordship,
Only my lord, my name was included wrongly, my lord. Instead of Kamini Das, it should have been written Kamini Bala Das. So that was the difficulty. After that, we submitted all the documents before the concerned authority. And my lord, till now, it has not been paid.
What are your instructions?
as per my instruction, in pension, his name, his wife was explained, declared as expired. After that correction, department received the has been issued by Pension Security Authority after being satisfied for correction of the under process, Lordship. And from this instruction, it is not clear that about the correction of his now petitioner's name, Lordship.
It has been corrected, my lord. We have got a letter from the concerned authority. It has been corrected.
Corrected.
It has been corrected.
When that instruction I had not.
It has been corrected, my lord.
Kindly grant 3 weeks time, Lordship. I will file affidavit, Lordship.
It has been corrected by which order?
Yes, my lord. Well, Yes, my lord, I just want to take your lordship to page 23 and Annex 6. Page 23 and Annex 6. I'm just reading out the relevant portion for lordship's kind convenience. On receipt of representation from Srimati Kamini Baladas, late so and so, a date of retirement with effect from so and so, date of death is in regards into correction of name Srimati Kamini Das to Srimati Kamini Baladas instead of Srimati Kamini Das. This office has verified all the documents submitted by Srimati Kamini Baladas. The pension sanctioning authority, after being satisfied with the period with the proposal order for correction of the name of Srimati Kamini Baladas, which was wrongly mentioned in the PPO book, for avoiding further complication by the pension disbursing authority. Copy of the documents submitted by the appellant are enclosed here for kind perusal and further necessary action, please. It has already been corrected, my.
Already corrected, you examine this and release it.
Yes, Lordship, that instruction not proper, Lordship.
You examine it.
Yes.
Is this page number 23? Have you
Yes.
seen page 23?
Yes.
Now, if this correction in terms of 23 is already done,
Done.
you take all steps to incorporate the correction and release it.
Yes, Lordship.
Yes, it is corrected already.
Mild, correct problem.
Kindly fix after opening of after vacation, Lordship, reopening on immediately.
You do one thing, you obtain your instructions on 25th or 26th and
Yes.
see whether this document, is there any confusion
Yes.
with this document at
Yes,
page
Lordship.
23? If not,
Yes, Lordship.
the matter can be closed.
Yes, Lordship.
List on 26th,
Yes.
26th of September.
Obliged, Lordship.
Enabling the learned CGC, representing the respondents to obtain instructions on the order dated 12/12/2020. What is this? 12/12/2020?
12/12/24, my lord. It is a copy of the memorandum correspondence.
Page number 23.
Yes, ma'am.
What is the date of the order? On the memorandum.
That is when 12/12/2024.
20?
Four.
4.
Ma'am.
12/12/2024. Issued by the railway authorities, which is enclosed as Annexure 6, page 23 of the writ petition. The council of the learned CGC will obtain instructions as to what steps have been undertaken in terms of this order. And so that if the railway authorities have already accepted the correction sought for by the petitioner in the pension papers of her late husband, then there should be no hurdle for release of pension other than retirement benefits.
Highly obliged.
These
my lord.
limited instructions, matter is fixed for 26th of September.
My lord. Highly
Obliged.
obliged. my lord.
Please, Lordship, in this matter, we were asked to bring the record, my lord. My lord, we are awaiting our instructions, my lord, in this case, my lord. Matter may be fixed after immediately after the vacation, my lord. I'll be getting my full instruction. And my lord, one more thing, my lord, just a request, my lord, our name, can our name be reflected, my lord? We are the main party in this case, my lord. Our names are not showing in the cause list also. GAD. Agriculture is showing, man.
No, we'll try to direct the registry to record it, but you
Fine.
should also maintain a diary.
So we are maintaining, my lord, just for the
Then it is all right.
convenience, ma'am.
Appeal not filed.
Your lordship, in this case, she was suspended twice, your lordship. Initially, she was suspended, a departmental proceeding was held. Thereafter, punishment was awarded, she was reinstated in service. And thereafter, again, when she joined your lordship, she was suspended by citing section 6C of the 61C.
61C, my lord. Lordship, on the last occasion, the record was called, my lord. We'll be bringing it, my lord. So Lordship will fix it after the vacation, my lord.
All pleadings are complete? No.
We'll be filing a thing also, my lord, affidavit also. It's a new fresh case, man.
Right, Mr. T. Deori for the petitioner, Mr. A. Fupan for GAD.
GAD, man.
Mr. Fupan submits that he requires further time to file the affidavit. Mr. T. Bora for
6.
respondent 6, Ms. G. Bora for respondent 2. On the prayer made by the council for the respondent is taken on 27th October. The respondents will complete instructions and file the necessary affidavits.
Very grateful, your lordship.
Name may be reflected.
Names of all councils, including the standing council, will be reflected in the registry by the in the cause list by the registry.
Deeply obliged.
Very grateful, your lordship.
34.
In this case, my notice was issued, my lord. Today is returnable that, my lord.
My lord, instruction awaited in this meeting.
Mr. N. Sharma for petitioner, Mr. Radhor representing the respondent submits. Instructions are awaited. He prays for further time. Accordingly, list again the month of November, first week of November, enabling the respondents to complete their instructions.
Here also, my lord, instruction awaited, my lord. Very short notice was given, my lord.
This lordship will be given another two.
Heard Mr. S. Oak for the petitioner, Mr. Hardford, representing the respondents. Submits that the instructions are awaited in place for 3 weeks of the time. Accordingly, let the matter be listed in the month of November on a date to be fixed by the registry, enabling the respondents to complete their instructions. That's the matter.
But respondents files counter affidavit, we need to file reply, my lord.
Mr. N. Bora for the petitioner submits that he would like to file the reply affidavit to the counter affidavit filed with the respondents. This after 3 weeks, Mr. R. Board for the respondents.
Much good.
That is 28 to 73.
Seven to give.
Well, this case released to the special recruitment, my lord. On the last occasion, your lordship was pleased to ask for the departmental authority, my lord, to bring out about the status of our reserve.
Where is the authority? Where is the
Gogoi-
health department?
Mr. B. Gogoi, additional AG is appearing in this matter.
Yes, yes.
I've just called somebody to call him.
Right. We'll call up.
Mr. Upamanyu is here. otherwise-
By this time, other matter, lordship can take it.
May I point out one?
One, yes,
Learned additional advocate general is on lakes, lordship, after some time, lordship.
yes,
Second up, could be there. That's the second up, man.
all right, yes,
The OM, my lord, they have filed a 3 OM, my lord. Actually, the OM issued by the central government, my lord.
we'll take it up in the second half.
Yes, my lord. There is a violation.
Highly obvious.
Item 74. Also, my senior is on lakes in court number 1. That may be taken after.
The joint request matter stands deferred to be listed after 3 weeks.
Lordship, in item number 75, we have filed the affidavit. In item number 76, I received the instructions on Friday, this Friday. So I need some time to file the affidavit in item number 76.
Yes, you want to file a reply?
Reply in 75.
Item 75, counsel for the petitioner prays 2 weeks' time to file the joint affidavit with the affidavit filed with the respondent. And in item 76, the respondent counsel prays for further time to complete instructions and file his counter affidavit. They are made, both the petitions are allowed list again after 3 weeks.
Highly obvious.
77.
Nine appears for the petitioner on both list again from after passed over. Passed over.
Item 78 to 80.
Yes.
Let me have another. The petitioner my lord, earlier, they were served as a constable of railway protection force, and they have been found medically unfit. And thereafter, my lord, they have been appointed as a cook, which is and they have been found fit for C1 category of job, but they have been posted as a B1 category of job.
Where is Mr. Roy? CGC?
Yeah.
Who's for the respondents?
And my lord, I have already submitted an additional reply, my lord, wherein I have annexed a letter issued by the principal chief secretary, my lord. It is an admitted fact, my lord, that the post of cook is it falls under B1 category of job.
Where is that? Additional affidavit in reply.
Reply, my lord.
What basis are you saying it? B1.
Additional reply. Additional reply.
Where is the medical report against you? Where is the medical report?
Yes, ma'am. Annexure B, page 13. Reply to last one.
13.
Page 13, Annexure B.
30 or 13?
13. Annexure B.
13.
Thank you, sir.
Yes, Mr. Roy.
My lord, this matters are under consideration, lordship. I just now talked, lordship, which is, let it be immediately after the vacations, lordship, there will be.
The only problem, my lord, for the last few months, my lord, we are
It
without
is under
salary.
consideration, my lord.
We are without salary, my lord.
You get your salary.
Yes.
Consider your
Lordship.
area salary, everything.
Lordship. Immediately after the vacations.
Mr. S.S. Roy, learned CGC submits that. Mr. Rafiq, learned counsel to the petition, submits that the petitioner before the court have been found to be in medical category C1.
C1.
And they have been appointed as cooks.
Yes.
However, by the department's own letter, which the learned counsel has referred to in the additional affidavit in reply filed by the petitioner for cook, minimum medical standard of medical classification B1 is necessary. And as the petitioner is medically classified as C1, he is not suitable for being employed as a cook. Mr. S.S. Roy, learned CGC on the other end, submits that these matters are presently under reconsideration.
Yes, sir.
By the appropriate authority. He therefore submits that the matter be listed immediately after reopening. That view of the matter, let the matter be listed again on 15th of,
Lordship.
17th of October.
Lordship.
17th October. We had passed over your matter, you were not there.
My reads can be taken, my, I apologize.
Yes.
Regarding suspension, my lord. Suspension order.
What steps have you taken?
Yes.
Lordship, the inquiry is going on. Lordship, it is at the taking stage of taking evidence from the witnesses, statement and witness. It is at that stage, Lordship. And he is receiving the subsistence allowance. Suspension is still on, Lordship.
When was the show cause notice issued?
17. After 90 days, my lord.
9/10/2024.
No, sir,
Uh-huh.
that is suspension order. The 17th of March 2024,
You are placed under suspension on which, by which order?
page number, my lord. Page number 23, my lord. Annexer 6. 10/2024. Group 17 should be sitting.
Then what about your review? Review?
No review was done within 90 days, my lord.
Lordship, within the period, as per the,
Your order says pending trial of pending trial of disciplinary proceedings. You have already drawn up.
yes, on 17/3/2025.
So therefore, why are you keeping him under suspension?
Yes, no.
That
The
Lordship,
order says pending trial.
Pending.
So you've already drawn up, so there it requires a review. Whether
that they
further-
have not done, Lordship, I had telephonic instructions specific on this point. The concerned officer who is now the disciplinary authority, he had no knowledge about that, Lordship, but the inquiry of is continuing. It is at the stage of the evidence from the witnesses.
You are receiving your
Subsistence allowance.
allowance.
75%
Yes,
is receiving.
It can be reinstated, my lord.
Why?
Now,
The
we have,
inquiry proceeding is going on now.
my lord, we have,
Because the department will have to now take into consideration whether your reinstatement will hamper the proceedings. We can permit the department to take a call that you may be reinstated and posted anywhere else.
Yes, Lordship.
If you are agreeable to that, we can direct them to consider it.
I have to
without-
take
without-
instructions.
Huh?
I have to take instructions from the client. Otherwise, after the submission of his reply to the SOCO's notice on 17th March 2025, the SOCO's notice they have given, he have also given a reply, another representation to the concerned authority, means the jurisdiction officer, my lord, to reinstate
Now
with
he
a
says
prayer.
that it is in the stage of
Taking evidence from the witness.
How long it will take?
yes, Mr. Counsel. The gentleman in the second row.
Second.
Please come forward. This courtroom, you are permitted to enter the courtroom because the court permits you.
Yes, Your Lordship.
Don't treat it to be your dressing room.
Yes, Your Lordship.
Whatever dresses you want to put on, take off, do it outside the court.
Yes, Your Lordship. I made a mistake, Your Lordship. I made a mistake, Your Lordship.
Don't do it.
Okay.
I
Alright.
Apologize.
We can permit you, we can direct the court to, we can direct the department to consider reinstating, but at outside the jurisdiction of your presence. Because they will have to take into consideration whether your further suspension is required, not required. You take instructions
Yes,
from your client.
After 10 minutes or 15 minutes, I can take instructions.
Second half,
Second,
2 PM
yes, highly obliged.
at 2 PM.
For hearing, I think 81.
May I please your lordship? Your lordship, Mr. R. Provijari appears for this matter. He's on legs in code 5. Matter may be passed over for the time being, your lordship.
What is your claim here, Mr. Islam?
My lord,
for pension, old pension, 1900. Similar case is already decided in our favor. In additional affidavit, we have annexed a
All right, we'll take it up in the second half. Second half.
So additional items 1 and 2.
Yes.
Matter.
Yes.
And last occasion, my learned colleague took time for my making submission today, madam.
Oh.
My part is over, madam.
Oh.
Lordship, so far item number 1 is concerned, Lordship.
Hmm.
Yeah, so the law is, I have seen the Lokesh Kumar's judgment also, Lordship.
Hmm.
And in view of that, Lordship, I agree with the legal point submitted by the petitioner, Lordship.
Hmm.
But in item number 2, Lordship,
Yes.
in item number 2, there was no determination as to the age of the petitioner, Lordship.
Hmm.
In item number 1, what happened? He was arrested, and even he has been acquitted, Lordship.
What is the case number? Item 1? 25.
Item number is 25, Lordship.
25. So,
In item number 2 is 612, Lordship.
yes. So item
Yeah,
1,
Lordship.
item 1, he was convicted, not convicted, there was some order passed by the Juvenile Justice Board.
Correct, madam.
So he is claiming protection under the appropriate section under the Juvenile Act.
24, Lordship. Yes, Lordship.
24.
Lordship.
So therefore, non-disclosure will not be material.
Material, Lordship. Because it's not obligatory on the part of the Lordship that employee or the act which was done during the juvenile, Lordship. And to that extent, Lordship, I agree on the point, Lordship.
What is the judgment?
But in item,
what is the judgment that was cited, Mr. Kato?
My lord, it is, my lord, on the last occasion I have furnished one Lokesh Kumar, my lord, versus
Union of
Union of India, my lord. Latest judgment.
Do you have this citation?
Citation, my lord, it is downloaded from the, my lord, website. It is criminal appeal number, number so and so 2005, arising from special leave petition criminal, my lord, number 851 of 2025, my lord. Parties name are Lokesh Kumar versus State of Chhattisgarh and other, my lord. Reportable judgment of the State of Chhattisgarh and another, my lord. It is reportable of the Honorable Supreme Court.
Date of the judgment? What is the date of the judgment?
Date of judgment, my lord, it is 18 February 2025 by, my lord, the Justice Bikram Nath and Justice Sandeep Mehta, my lord.
Okay.
18 February 2025, my lord. Latest one, my lord. After that, my lord, there is no judgment, my lord, as per as I have searched from the, my lord, website.
Okay.
So since my friend is, my lord, agree with that, my lord, my lord, and the another, my lord, in second, my lord, read petition number, my lord.
Wait, so item number 1, we are closing it, disposed in terms of the law laid down by the apex court. Yes.
My lord.
Yes, item
And
2.
in item 2 also, my lord, only dispute is, my lord, my friend is, my lord, at that relevant point of time, he was not, my lord, the minor, my lord. But, my lord, from the record, everything is, my lord, our pleaded case is also, my lord, he was minor and filion rider, my lord. He was the filion rider, my lord. Therefore, In the investigation itself, my lord, the investigation authority has given a clean sheet that, my lord, the pillion rider, Mr. Gumluk Karbak, my lord, one of the, my lord, the pillion rider is not involved at all in the case, my lord. So in charge sheet itself, my lord, if my lord peruse, my lord, I am taking a Gumluk Karbak. A Gumluk Karbak case, my lord, in the 6126, my lord. Read petition number 612 AP 2024.
Yes.
My lord, if perused, if lordship perused the, my lord, the charge sheet copy at page number 38, my lord, it has been clearly mentioned that the Gumluk Karbak, the petitioner herein, is not at all involved, my lord. Just for a moment, my lord, may I take your lordships to my petition, page number 38, my lord. Under the above facts and circumstances, a prima facie case has been found well established against the alleged accused number Dejo Karga, my lord, the first read petitioner, 18 years, and son of so and so, and son of so, Wesiang, under section 279, 338, 304A IPC, my lord. However, the other arrestees, namely, my lord, Thomas Hango, there was another person, my lord, and Bokar 2, Bokar Hango, 3, Mokurole, 4, Gumluk Karbak, my lord. He is the petitioner, my lord, may be freed from the charge, as there was no any collision or and most of them were fill-in writers, my lord. Rather, these persons may be treated as witness of the case, and the Honorable Court is pleased to inform that one of the prime witness, Sri so and so, are, my lord, that other part. Now, my lord, this petitioner has been, my lord, freed from the charges, my lord, after during the course of investigation. He is not at all involved, my lord. And moreover, my lord, he was same age of, my lord, minor age, my lord. So therefore, my lord, same law will applicable, my lord. And my lord, we have also given them at that point of time, if lordship again perused, my lord, his age, page number 38.
Order of the principal magistrate is only in respect of the first.
Yes.
First writ petition.
Dejo Karga.
Okay.
And just to confirm, my lord, namely, my lord, in 612, my lord, writ petition number 612. My lord, just to clarify the age, my lord, page number 36 again, my lord, of charge sheet, my lord.
Yes.
My lord, my name is reflected at serial number 4. Gumluk Karbak, my lord, petitioner. And father's name is given. Date of birth is also given, my lord. Date of year of birth, my lord. 12 years, my lord. At that time, my lord.
17 years.
Oh, sorry, I'm sorry, my lord. 17 years. I'm sorry, but extremely sorry.
17 years.
He's 17 years, my lord. So therefore, it is prima facie case, my lord. Moreover, firstly, my lord, he is not involved at all in
Was there
the
any
said case.
Was there any proceedings initiated pursuant to the report submitted?
No, my lord.
By you?
No, no, my lord. This has to be initiated against the, my lord, the past petitioner. Lordship has already seen. Initiated was against, my lord, in view of, my lord, this charge sheet. It is in respect of one Dejo Karga, past writ petitioner, my lord. But this is second writ petitioner. My lord, nowhere, my lord, the proceeding was initiated. And even, my lord, officers in charge has given, my lord, the certificate that no case is pending against so and so, my lord. And learned, my lord, trial court has also given, my lord, no case pending certificate, my lord. Page number 42, my lord, is the, my lord, the certificate given by the trial court, my lord. Page number 42, my lord.
42.
This is to certify that as per the verification conducted by the UDCA and with the staff of the court, there is no case pending registered in this court, criminal case, civil case, criminal case against Sri Gumluk Karbang, son of so and so, son of so and so, till date, my lord. And no proceeding was initiated as because, my lord, from the charge sheet, it is clearly mentioned that no case was found well established against the petitioner. But he was the, my lord, one of the witnesses, madam. So therefore, my lord, this is also, my lord, comes under the that immunity is inserted under, my lord, section 24 of the JJ Act, my lord.
Yes.
Same, out of same, my lord. Moreover, it is not serious and the grave nature of offense, even if, my lord, considers to be, if taken into consideration, my lord. It was just the Russian, my lord.
This charge was that you suppressed this information.
Correct, my lord.
What is the stand of the state here?
Same, my lord. They are saying that, my lord, firstly, they are, as he is the age of
The same ground loss. On the same ground lawship, his services, he has been discharged from the service lawship.
So why do you disagree with the proposition, Lokesh Kumar?
Lawship, here lawship, the age of the petitioner was not determined lawship.
No, but there was no case pending otherwise.
He was arrested and released on bail lawship. This fact has been suppressed in the present case lawship.
He was arrested.
Yes, he was arrested. In our affidavit in opposition, categorically, we have taken that stain lawship, which has not been lawship denied by the petitioner lawship.
No, but was there any proceeding initiated against him?
No, man.
No lawship.
Then what is the effect of?
Seems
He was not arrested pursuant to any conviction.
that's true lawship, but law says lawship, at least those things has to be disclosed lawship. When you are asked to disclose lawship. In our lawship, while employing him lawship, in that very selection process lawship, we have asked them.
Where is the disclosure clause?
Lawship, kindly come to the page 88 lawship.
88.
88 lawship. This is the lawship attestation form lawship in Annexure D lawship.
No, in the advertisement, is there anything?
No, man.
In advertisement is not there lawship.
Okay. Then this form is a part of what?
It's a part of the lawship, part of the selection process only lawship. While filling up the form lawship, this also has to be filled lawship. Advertisement is one thing lawship. In response to the advertisement, the petitioner has to file an application and this attestation form lawship declaration.
In the declaration, where is it mentioned about criminal matters?
Lawship, kindly come to page 88 lawship, my affidavit.
88.
88 lawship will find this is the form lawship, under which lawship the petitioner is supposed to furnish his details lawship. Lawship will find, see the first paragraph, that is the warning.
No, but the details
type copy. The type copy is
yes. Where is the type copy?
Type copy is at page 91 lawship.
All right.
The serial number 1, 2, and 3 lawship. This first warning. Before you filling up this form lawship, this is the warning instruction to the employee lawship. The one is what one says lawship. Furnishing of false information or suppressions of factual information in the attestation form would be disqualifications and is likely to render the candidate unfit for employment lawship. Likewise, lawship 2, if detained, convicted, debarred, so and so and so and so.
You are
and relevant is
you are referring to
page
93.
Lawship, I'm taking lawship to the page 93. Before coming to that lawship, page 91. Before coming to the page 93, I'm taking lawship to the page 91.
Yes.
The first three instruction lawship, that's in the column of warning lawship. Under the column warning lawship, clear instruction has been given to the employee, the candidate, before filling up this form lawship. You have to furnish the details with correct facts lawship. Even lawsuit intimated lawsuit, if you file false information or suppressions of any facts, then it may render you unfit for the employment lawsuit. Then lawsuit, kindly come to page 93 lawsuit.
Ninety?
93 lawsuit.
Yes,
Column 11 is a relevant lawsuit.
yes.
Have you ever been arrested, prosecuted, kept under detention, or so and so and so lawsuit?
Mm,
Answer is no.
mm. Yes.
For purpose of our lawsuit, action lawsuit, it's not necessary one has been after one has been arrested lawsuit. There must be some consequential proceeding must be there lawsuit. If you were ever arrested lawsuit, then you must disclose that lawsuit. And that has not been done by the petitioner. So upon which lawsuit the authority has discharged him from the service. And in our affidavit lawsuit, we made it very clear lawsuit he was arrested and released on bail, though subsequently nothing has been found against him lawsuit. And that has not been denied by the petitioner.
Mm.
And law is very clear. Law is very clear lawsuit. I'm just placed two citation lawsuit. Whether an employee lawsuit, a candidate has to furnish the lawsuit details about his antecedents or not. If he was ever arrested lawsuit, then he must disclose that in the format whatever lawsuit is provided lawsuit.
Yes.
I'll place two citation and rest I'll leave to this court lawsuit.
All right.
One is lawsuit the after Singh's case lawsuit. That is 2016 8 SCC
2000?
471. 2016 8 SCC 471.
Yes.
2016 8 SCC 471.
Paragraph?
Paragraph lawsuit 38.
Okay.
Then next is lawsuit 2024 SCC online. SC 1769. Paragraph 20 to 26.
What is the name of the party?
Here lawsuit party is Union of India and others versus Sisupal Elias Sipal.
Yes.
And
All right.
one more is lawsuit. 2024 SCC online. This is of Calcutta High Court lawsuit. CAL 2376 lawsuit. The last citation is on the lawsuit whether the discharging an employee from service is amount to loss stigmatic or not. If it's not stigmatic lawsuit, then lawsuit that particular opportunity of hearing may not be required lawsuit.
Hmm. So which Calcutta High Court? Calcutta High Court judgment.
Calcutta.
What is the party name there?
Lawsuit Siampada Patra versus Union of Indian Others. And there are, on this particular point, there are more judgments of Honorable Apex Court also lawsuit. If it's not stigmatic lawsuit, and it's not going to lawsuit affect the future lawsuit employment of the employee lawsuit.
They were appointed on provision.
Yes, lawsuit. During the training time period only, within a period of 3 months lawsuit, that this offense was detected and accordingly discharged.
Okay.
Because his age was not determined lawsuit, but therefore lawsuit, otherwise I would not have lawsuit place all these things lawsuit.
Okay.
My lord, in the my lord, in the charge sheet, my lord, it has been clearly reflected, everything has
So
been
that
clearly.
we are not denying lordship, that we are not denying.
My lord, in Lokesh Kumar case, my lord, it has been clearly dealt with by my lord, the Honorable Apex Court, wherein my lord, regarding all aspects, my lord. So if on the last occasion, my lord, I furnish this judgment to your lordship, and
Yeah.
my lord, it has,
We
and
have-
another judgment,
Ah,
my lord,
we have taken,
another judgment,
yes.
yes, on the last occasion, my lord, lordship has taken this, my lord, judgment which I have relied upon, my lord. And another judgment, it is also handed over to your lordship on the last occasion, my lord, Santosh Kumar Yadav, at the rate of Ranjan, sorry, at the rate of Ranjan versus Union of India and others, my lord.
What is the citation?
Citation, my lord, it has also been, my lord, taken out from the, my lord, the website.
Hmm.
It is, of course, my lord, of 2000, my lord, 27 January 2025.
Okay.
My lord, it is High Court of Delhi and Delhi at New Delhi, my lord.
The Delhi High Court judgment.
My lord, everything has been relied upon, my lord, regarding that section 24 of the JJ Act, my lord. Para, my lord, 31, 30, 31, 32, 33, 34, my lord, and 35, my lord, 35, 37, 38, 39, and 40, my lord.
Okay, we'll
My
pass
lord.
out.
My lord.
Heard counsel for parties reserved.
Well,
Yes.
Deep
Yes.
dive.
Offline.
Much obliged.
Lucky to file alone.
That is 38 to 73.
Yeah, my lord, I had a talk with Gogoi, my lord, he could not have brought the result of us. He's there.
Yes, Mr. Gogoi.
My lord, I have got the reports
Amar ki nahi paisa.
of item number 38, 44 to 48. But my lord, so far as my learned friends, my lord, items 39 to 43
And 52. No, no.
and 50 and 52
This is the serial number.
and 52, my lord. Those are awaited, my lord.
No, no, more to whole.
Because of this situation, my
39,
lord,
40,
staff are
41,
not there.
42, 43, 52.
What does the report include, reflect?
My lord, may I just place it, my lord, just. They are within, my lord, below 40. Twice they've been found to be below 40.
So, Amar file to do.
Item number would be, no?
No, we wanted to know
My lord.
how these tests are being carried out.
Well, what notification or guideline has been followed?
No.
Procedure.
You see, the joint director had already given
Yes.
disability
138.
certificate.
My lord.
That disability certificate is in terms of the rules by the state as well as by the
My lord.
union.
My lord.
So this is to be used to identify whether the person is a
Yes.
PWBD.
My lord.
This certifies that this is PWBD.
My lord.
Now you again make them undergo another medical test.
That's it.
And then you recertify that they're below the
40.
benchmark
Yes. they are
disability.
disability, yes.
So there has to be a finding that
But same yardstick has been applied and now it has been found to be. That I can manage because my lord, the guidelines remains the same, be it the medical college or the joint director.
correct.
Central government notification will remain the same.
See, firstly is whether you have the authority to go for a subsequent medical test in view of the rules are being silent. Let us say you do. let us say that it is permissible to do so. At least in one writ petition, this has already been upheld by a coordinate bench and no appeal has been filed. But even if you do, then you have to justify that the person who claims to be 40% and above, these are the tests conducted, we find him below 40%.
But that I can place, my lord.
That is what is necessary.
Oh, I thought, my lord, that reports will.
No, that is the
Yes,
report.
Yes. My lord. That I can place, my lord. What yardstick has been applied, the same or not, my lord. That I can place. My lord. That is, my lord, uniformly applied in every case. Because even the
No, but
percentage are mentioned.
That we don't want a report from an authority. We
No,
want-
not report, my lord, that statement
Ah.
from the, my lord, principal of the Guwahati Medical College who has constituted the board and all. He can, my lord, give a
No,
clarification.
we don't want his report. We want to know, let us take this particular matter.
My lord.
You get the records and satisfy us that this is the yardstick followed
Lordship.
and this has been found by the.
No, in general also he can give, my lord, that this, all these persons have been, my lord, so far as their verification is concerned or re-verification is concerned,
That will do.
has
but
been done by
as a-
following this.
As a test case, you give us 4
Yes, my lord.
matters
Yes, yes.
to show
That I
the-
can do, my lord.
how these tests
My-
were done by the medical authorities.
Lordship.
And what was and how the results came to be arrived at.
Lordship.
And whether these procedure is the procedure laid down by the guideline.
Lordship. That I can put. 115, my
My
lord.
lord will see, my lord. Lordship, kindly have a look, item number 39. For a moment, my lord. Item number 39.
No, no, sir. No.
That's 39 to common. Lordship, kindly turn to page 31. This is the certificate issued by the competent authority.
Yes.
Then Lordship, kindly turn to page 33. It is unique disability ID, my lord, by the central. After going through all these things, then they have issued the
That
certificate.
is what we are.
Yes, my lord.
saying.
They have not cancelled this one as on date. That's, my lord, for random sake, my lord. What happened to our status from the examination or retest? That is nowhere mentioned. No affidavit has been filed.
That is what we want to find out.
Yes,
We will have
my
the report from the medical board who has conducted that things. They will have to, my lord, clarify what yardstick they have applied and what is that particular guideline, my lord, which was followed.
No,
by
see. We want to see
the records.
whether the medical examination was conducted by that medical board
My
number one.
lord, my lord.
It is conducted as per your instructions.
That's-
So they must have recorded some findings.
Yes.
Supposing let us say for somebody suffering from locomotor,
Lordship.
you can't put him up before an ophthalmologist.
Yes, my lord. Of course.
So
Yes.
there has to be proper
Or before the orthopedic.
orthopedic.
Uh,
So they will conduct some tests.
Lordship.
We do not know whether it is an X-ray or an MRI or any other
Lordship.
accepted parameters
My lord.
in the medical science
My lord.
to come to a conclusion that this person, according to the medical board,
My lord.
has disability of benchmark either above 40 or below 40.
I got the point.
Now, if you are able to explain these medical reports, good. If you are not able to explain, then you'll have to find a way to as to how the
No,
medical
if
report.
required, my lord, I will call some expert also. They will be.
No, we don't want.
One or
we
two,
want
my
to.
lord.
We want to hear it from you. You show us and explain.
Lordship, I will,
how
I will.
how it has been
Yes,
done.
yes. Because similar situation arose in my lord while conducting the medical test for the medical students
Oh.
last year. So they were present and everything was explained, including those, my lord, notifications and guidelines and what tests they have conducted. For hearing, it's different, my lord. For eye, it will be different. Like
Blind
locomotor.
also.
But so far as your submission that once a certificate is issued, not cancelled, will mean that you are questioning the subsequent medical test.
My lord.
That has already
Subsequent,
been answered by a coordinate bench.
Yes.
That it is permissible.
Yes, my lord, permissible. Once we got selected, my lord, and they, my lord, did not declare my result as on date.
No, declare your what result?
My lord, after conducting my subsequent test,
Ah.
what happened to my?
You don't know.
I
That you
do.
get it on the next. Yes.
Yes, my lord, let
You
them
get
come
it
with
on the
that.
next.
That's why I said, my lord, if they file affidavit in item 39.
Why do they have to file? They'll bring it on record.
Yes.
They'll produce the records.
My lord, that will be.
Mr. Gogoi, you please
Yes,
on
I
the
got it.
particulars of Mr.
My lord, in fact, my lord, in
Yes.
those cases, affidavit has not been filed, I will place everything. my lord.
Right, and get the details.
On 23rd in that case, madam.
Right.
Immediately after the
My lord,
Diwali.
may I point something? In item, my lord, they have filed affidavit, my lord. Item, my lord,
23rd of February.
no, my lord. I just, there is no basis, my lord. They have created by, they have,
We'll examine all that.
23rd.
my lord, the OM, my lord, central government issued an OM.
Mr. Roy, we heard you on that day. We have noted your submissions. Now we want to find out what what is the process by which they have undergone medical test. We pointed out that a coordinate bench has already held that there is no infirmity in going for the subsequent medical test.
My lord, in coordinate bench, my lord, my lord, there was no central government, OM, my lord, but this is not the same, my lord. My lord, because in affidavit, may I kindly see the affidavit, may I point
We
out?
will examine everything on next date fix along with the reports. When do you want it?
The 23rd, my lord.
23rd October.
Well,
All right.
Lordship, may kindly indicate that the affidavit of the health department be provided to us, my lord. Not got that.
Affidavits filed, not served.
Not served on us.
In our cases, they have not filed any affidavit. They have said that the other affidavit will cover our case.
That has not been provided.
well, by tomorrow, by Friday, we will serve a copy.
You share your emails or whatever is there, they will give you soft copies.
No, it will be served. I
It
give
is
my.
already there in the record, you serve
Give
it.
soft copy, that also will do.
Yes.
Ah.
Same number.
All these matters be listed on 23rd, by which date the respondents may file their affidavits, if so advised in the matters where it has not been filed. Stop in the matters where the affidavit has been filed, petitioners are permitted to file their rejoinder affidavit, if so advised. Further, the health department will produce all the relevant records to explain the findings of the medical board constituted by the state, which had re-examined the petitioners and have found their disability to be below the benchmark disability of 40%. Stop. The relevant records to that effect be produced for perusal of the court by the health department.
My lord,
Can it be a part out, my lord?
It is part, huh?
Already.
yes, my lord. I have submitted a list of judgment, my lord, close, my lord, on OM.
We
close.
will hear you on 23rd, since we have already fixed the matter.
My lord, the petitioner herein, he is in the unit of Dhubri, but he is under the charge of circle 2 and 3. There are 5 circle in Dhubri unit, my lord. It can be changed in otherwise than 2 and 3. He is in the
Subject to there being vacancies and posts available.
2 and he is in charge of 2 and 3.
He is in charge of 2 and
2 and
3.
3 circle. There are 5
So
circles.
is it possible to put him in some other circle?
Lordship, it will be decided by the Deputy Commissioner of Taxes of that zone. Under that zone, Lordship, Bongaigaon, Kokrazar, and Golpara comes. Lordship, wherever they finds it fit.
All right.
Lordship.
Third, MSN Gogoi Learned Counsel for the petitioner, Mr. P. Chaudhary Learned Standing Counsel Finance.
I have a small prayer, my lord.
Yes.
His wife is an Alzheimer patient, actually, my lord. That's why he needed in Dhubri.
See,
We have prayed for.
either you wait for the outcome of the proceedings. We are only saying that we are giving you liberty to transfer these
Place the
to reinstate him
In any of the
other circles, which was not previously held by the petitioner, so as not to hamper the.
Yes.
But we can't say whether it will be in Dhubri or Borpeta or anywhere else. We can't say that.
Very well.
Heard counsel for the parties is Petitioner is aggrieved by the fact that he's been placed under suspension by the order dated 9th of October 2024. Stop. Learned counsel for the petitioner subjects led by the said order. Petitioner was placed under suspension pending trial of disciplinary proceedings. Stop. It is submitted that subsequently the charge sheet was filed, was served on the petitioner, but beyond the period of 90 days. Further, the petitioner is continuing to be under suspension without there being any review undertaken by, without there being any review to examine the necessity of continuance of the suspension order issued against the writ petitioner. Stop. Counsel for the petitioner submits that this is completely in violation of the law laid down by the Apex Court in Ajay Kumar Chaudhary and followed in several judgments rendered by this court. It is submitted that since there was no review undertaken by the departmental authorities, the suspension order should be interfered with. Stop. Para. Mr. B. Chaudhary, learned standing counsel finance, on the other end submits that the matter is the departmental proceeding is at the stage of examination of witnesses.
Yes.
Stop. He, however, clearly submits that no steps have been undertaken for review of the continuance of suspension in respect of the writ petition. Stop. He submits that once the inquiry is concluded, whatever orders are passed by the disciplinary authority, depending on that, the petitioner's suspension will also be considered. Para. What is the judgment? Any judgments you're relying on? Having heard counsel for the parties.
Ajay Kumar Chaudhary and Nepal Chandra.
It is seen that the petitioner has been placed under suspension by the imperial order dated so and so. He has continued to be under suspension. Stop. The departmental proceedings have been initiated, which however has not been concluded. Stop. When were the show cause issued?
Lordship,
17/3/2025.
17.
Perusal of the judgment of the Apex Court in Ajay Chaudhary. It is seen that the Apex Court directed that ordinarily suspension order is to be reviewed within prior to expiry of 90 days if the departmental proceedings have not been served. Departmental, the show cause notice has not been served. So there's a division bench judgment. For a compilation to assist suspension. The relevant paragraph of Ajay Chaudhary is extracted below para 21. Stop. Following this judgment, several judgments and orders have been passed by this court. In so and so versus so and so, the division bench of this court while examining a matter of suspension, came to a finding that held that unless review is mandatorily undertaken within a period of 90 days for continuance of the suspension, the suspension order is required to be revoked. This is the finding of the division bench in State of Assam versus Ajit Sonwal reported in so and so. Stop. The division bench held that unless the show cause notice is issued within a period of 90 days, the review of suspension is mandatorily required to be undertaken within prior to expiry of 90 days. Stop. But in the facts of the case, on the basis of the submissions and the materials placed before the court, it is seen that show cause notice, although belatedly, was issued on 17/3/2025.
Yes.
Stop. Departmental proceedings are underway and is presently at the stage of examination of witnesses, as is informed by the as is submitted by the counsel for the state. So, under such circumstances, taking into account the judgments referred to and relied upon by the counsel for the parties, it is seen that while review of show cause notice was not undertaken within 90 days, nor review of suspension not undertaken within 90 days, nor any show cause notice was issued within 90 days. Ordinarily, this court would be inclined to interfere with the suspension order. Stop. However, since it is submitted that the disciplinary proceedings are underway and the reinstatement of the petitioner at this stage without conclusion may have adverse effect on the disciplinary proceedings, this court is not inclined to interfere with the suspension order at this stage. Stop. During the course of the hearing, the counsel for the respondent had submitted that there are 5 divisions.
Four.
Divisions or circles or what? What do you call it?
Lordship, circles. It will be.
Circles. 4 or 5?
5 circles.
5 circles
5 circles.
under the Deputy Commissioner of Taxes.
Yes, my lord.
Dhubri zone, ma'am.
Dhubri zone.
Where is he serving?
He's in Dhubri.
Under which office?
Under respondent number 4, Assistant Commissioner of Taxes.
Taxes.
It is submitted that the petitioner is serving as a senior assistant under the Assistant Commissioner of Taxes,
Right.
Dhubri Unit, Dhubri. Stop. Under the said Office of the Assistant Commissioner of Taxes, Dhubri Unit, there are as many as 4 circles.
Yes, boss.
Stop. The petitioner was posted as a senior assistant in
2 and 3 circle.
circle number 2 and 3, Roman 2 and 3. Stop. Is the show cause notice enclosed here?
Lordship in the affidavit, Lordship. Page 29.
The show cause notice is enclosed to the affidavit filed. And the charges are, there are 4 charges brought against the petitioner. Stop. Under such circumstances, this court is of the view that while it may not be conducive to reinstate the petitioner immediately, during the pendency of the departmental proceedings in the in the office in which the petitioner was serving, during which he was suspended, namely under the circle 2 and 3, considering that there are two other circles available, namely circle 1 and circle 4, the respondent authorities will consider the case of reinstatement of the petitioner in any of these two circles during the pendency until the conclusion of the departmental proceedings. Stop. The respondents will examine the matter and pass appropriate orders within 2 weeks from the date of receipt of a certified copy of this order, and will consider the reinstatement of the petitioner in any of the two circles, namely 1 and 2, under the office of the Assistant Commissioner of Taxes, Dubri Unit. So, the petition accordingly stands disposed in terms of the above. Yes?
Highly obliged. Sir.
Hearing item 81.
Please, Your Lordship, Mr. Arbor is still on legs, Your Lordship.
My lord, 2000.
So, you said it is a covered matter.
Some
Huh?
dispute is there, Lordship.
Huh?
Some dispute is there
So-
regarding similarity, Lordship.
Those dispute have resolved. I have filed written submission.
What is it that you are asking in the writ petition? What is your prayer?
Pension under 1969.
Pension.
Yes.
Are you still serving or you retired?
Retired in the year 2015 in the month of January. My lord, I was under the sub-registry office at Mukalmo.
No, let us continue this hearing after the vacation. It will take some time.
Lordship, in the meantime, I have prepared the written argument also and supplied to them also.
Have you supplied to the court?
Yes, Lordship. On, but order dated 12/8 of 2025. Lordship, may kindly peruse.
Okay.
Thirty-one 7/2025. The written submission. Whatever dispute I have. Right,
What is that order that you are relying on? Covered matter. You said it is passed by court and bench.
My lord. That order.
We have the court.
The writ petition itself that is there, but additional affidavit, additional affidavit filed on 2023/225. That is annexure 13, page 125 onwards. My lord. Additional affidavit filed in the month of March. This is the writ appellate court's order, and prior to that, because the matter went carried to the appellate court also by the state, appeal is also dismissed. In contempt proceeding, already pension is paid to the sub-registrar. I am his LD. Annexure 12, my lord, page 109. In the additional affidavit. Because the judgment, this initial judgment was of 2014, and annexure 13, page 125, that is of 12th May 2023. The division bench findings.
Additional affidavit.
Yes, that's it. Filed on 2023/2025. Single bench's judgment is at page 109.
That
We
is
are
why-
unable to file, one is 3rd May 25, is that the one?
3rd May,
Huh?
25, no. 2023-2025. An additional affidavit filed by the petitioner to clarify the query made by the honorable court. violating the order.
2003-25.
Yes.
Okay. Where is that order?
Kindly come to page 109, annexure 12. That is the original order. That is order dated 22/9/2014 by my Lord Justice Ujjwal Gohain.
We'll hear it after the vacations. We'll
My
request-
Lord, otherwise, my petitioner is an old ailing person, 70 plus now.
We'll keep it immediately after reopening.
Lordship,
on-
Lordship.
On,
One day hearing will be enough because now every filing is complete. Matter is covered, therefore, every clarification I have filed written submission also for convenience sake.
23rd. 23rd October.
23rd October. All right.
Matter be listed on 23rd October for final disposal. Yes.
Deeply obliged.
I think let it be.
I please a lot. Also, by the last order, we were directed to bring the bank books of payment of some medical dues. Also, we could get only one statement has been provided to me. But the rest, we need some time, Lordship.
Why?
Because we could not trace all.
What do you mean you could not trace all?
But you kindly see the last page.
Yeah, I did not receive any copies of it.
You want me to display the statement.
Give him a copy. Why are
Yes,
you
yes.
shying away from all this?
No. Lordship may see the last but one, the last page. Avinash Bora, it's a 1, 2, 3, 4th column.
Last
Fourth row.
page.
Yes, last page, 4th row, Lordship, second.
Ah.
Avinash Bora, 18 lakhs debit is 18 lakhs 06,758. That is the gratuity and leave encashment amount we had paid to him, Lordship. The rest, Lordship, we need some time to collect the statements, Lordship.
This has been paid to you.
Lordship, they are submitting randomly, Lordship. In last occasion, this honorable court.
You examine this and tell us whether you have received this amount or not.
Lordship, in last occasion, this honorable court, in earlier occasion also, this honorable court specifically ordered them to submit against their submission. Lordship. They submitted that by this document. Kindly refer to their last affidavit. Their last affidavit submitted on 20 might be 24th of July 2020.
You are directed to bring on record by affidavit.
Lordship, because we could not get all, that's why I'm seeking some time.
Lordship, now it is how it can be possible, Lordship, to get a data from within 1 hour. A bank statement can be get, Lordship.
Why have you not?
Kindly consider.
Why are you unable to produce this information? These are all available in your records.
Yes, Lordship, we are tracing it, Lordship.
What do you mean tracing it?
They are submitting.
These are all printouts of
banks
available from the computer. You are not taking it out from your old ledgers.
Yes, Lordship, but
within 5 minutes, 10 minutes, they will get, Lordship. They are submitting. They
You
are not
produce it
submitting this
by-
document
produce
for
it on
last 2 years.
Thursday.
Lordship.
Thursday.
And you file it on affidavit. File your affidavit. Bring it on record by Thursday. Otherwise, we are calling up your officers. 25th.
Kindly mention in the order that they need to submit all the details.
In deference to the order dated 9/9/2025, the council representing the NRL has produced a bank statement printout of a bank statement maintained in the name of Numoligo Refinery, which according to the writ petitioner reflects that an amount of rupees 18,06,758 has been shown to be transferred to the account of the petitioner in person. Stop. Better. This court by the earlier order dated so and so directed the NRL authorities to produce the necessary particulars showing the bank transfer of the relevant amount from NRL to the petitioner's bank account in respect of the payments reflected in annexure 9 capital A and 9 capital B, the affidavit filed by the petitioner in person on 27/6/2025, as well as the medical bills claimed by the petitioner, which are stated to have been processed but not released. Stop. All these information were directed to be brought on record by way of an affidavit by 22/9/2025. Stop. There are today when the matter is called up, the counsel for the NRL has placed before the court a printouts of the bank statement, which stated reflects an amount of rupees 18, so and so lakhs being shown to be transferred to the bank account of the petitioner. This statement does not show the breakup under the various heads in which the claims of the petitioner are stated to have been processed and released. Stop. All these particulars as directed in the order dated 9/9/2025 are to be placed before the court on 26th September. The affidavit directed to be filed must be served on the petitioner for petitioner in person at the time of filing. Stop.
At least one day lawsuit. At least one day prior to the filing lawsuit, so that I can at least.
Today is 22nd lawsuit.
We are trying to get this before the vacation, otherwise we'll keep it after vacation. You want it after vacation?
No lawsuit before the vacation.
Before
the
vacation.
At least first of
Only 3 days.
for last 2 years they are getting
We had passed this order on 9th.
Yes.
May you come and ask for further time.
for last 2 years they are.
What are you doing? It is made clear if the direction of the court is not carried out, the court may proceed to pass consequential orders against the respondents. List on 9th, 26th.
One simple prayer, Lordship. Kindly mention that the details and particular may be provided with details.
You look into the order, whatever else you want, you point out to the court on the next date fixed, 26th.
9 is serial number 1 to 3, and for details and particular, Lordship.
No, we are only reproducing the order that we have already passed on 9th. So whatever direction was there, we are asking them to bring it on by way of an affidavit. All right?
Yes,